All right, good morning, everybody. As I said, thank you for the introduction, Allison. I'm really happy to be here. I will tell you right off the top of the bat, I love the Arc of San Antonio. I moved to San Antonio about 4.5 years ago, I guess, and I have a daughter who's now 25 with special needs, and when we moved here, she was 21, and I was a little bit lost coming. We moved from Boston, and I didn't know what services were available, what we had here in San Antonio, so I was a little overwhelmed. We came to the Arc of San Antonio, and we got a lot of help. And it allowed me to start working part-time. It was the Arc that gave me some good ideas. My daughter could never get a diploma in Massachusetts, and so she only had a certificate of completion. And so it was the Arc of Texas, or San Antonio specifically, that helped me realize she could go back to school for 1 year, which gave me a chance to get into the community. I am an attorney. I practiced a different type of law for about 20 years, but now that my daughter was aging out of the school district, I had to figure out what I was going to do differently. And because she went back to school, it let me start investigating programs, special needs trusts, guardianships, all these things, and this is what I've been doing the last several years. So I've been an attorney for much longer than I've done special needs planning. I wish I had done this from the very beginning. I took about 10 years off with my daughter and kind of dabbled in litigation and other types of areas of the law. But this is what I love. And I will tell you, I love working with parents of children or grandchildren with special needs because I get it from the parent perspective, and this is important information and can help us. So today we are going to cover kind of a plethora of topics, and we'll just go through it, and when you need a break, we'll go for an hour or so, see how everybody's feeling, and then we'll move on, and if you're feeling good, or take a break. We'll see how it goes. We've got about 3 hours. I think you'll all be insane if I talk for 3 hours straight, so we'll try to talk for a couple of hours, and then that way I can have quite a bit of time to cover questions. So as Allison mentioned, if you have questions, general questions where I'm not explaining something well, or you just need a little more clarification, go ahead and ask me. But if it's something very specific to your situation, let's wait till the end, okay? All right, we're gonna start. This is my standard legal disclaimer, and this just is me telling you that I am giving general advice, educational information. So don't say my lawyer told me this or that. This is not specific to your situation, just general advice. Okay, this is, by the way, is a picture of my daughter, Angela. And I took this picture. She actually looks different. She was on quite a bit of prednisone there, so it makes me smile because she's so much healthier now. She actually looks much different. But I love this picture because it kind of reminds me of the medical craziness we've been through. Anyway, I took this when Angela was about 18, and as we know, age 18 is a big age for our kids who have special needs. There's a lot of things we have to figure out, and so as I went around the room, it looks like most of you are right in that range, so that we're going to focus a lot on that transition phase, okay? When someone turns 18, mom and dad, or even legal grandparent, you no longer have the right to make decisions for your child or grandchild because they're 18, they're a legal adult. So you have to figure out, what are we going to do now that our child is 18? You've got a few options. You can let your child just manage and make their own decisions. Some of you are giggling. So that'll work for some people, but not for a lot of us. You can get a guardianship, a legal guardianship. That is taken care of in the court system. So it's not something where you just fill out a paper or have your child sign something. You have to involve the court. We're going to spend quite a bit of time going through that. Or you can do something less restrictive, an alternative. So we're going to cover those types of alternatives. There are 2 types of guardianships. This is important to understand. There's guardianship of the person and guardianship of the estate. Guardianship of the person is when you are making medical decisions. You're making decisions about residence. You're making kind of those general decisions. Guardianship of the estate is when you are managing money, okay? So for most people in this room, I would predict that if you do need a guardianship, it will hopefully only be guardianship of the person. We want to try to avoid guardianship of the estate if at all possible because it's going to be a lot more expensive. Okay, so, and when I say that, I don't mean the lawyer's fees up front. I mean over your lifetime. We'll get into more details, but guardianship of the estate, you're gonna have to use a lawyer every single year to report to the court. So we want to stick with guardianship of the person if we can, and we want to find alternatives to the guardianship of the estate. Okay, I've already mentioned this. A court-appointed guardian of the person is responsible for the physical well-being of an incapacitated person. That's the key definition. To become a guardian of your child after they turn 18 years old, they need to be determined as incapacitated. So the way they're determined to be incapacitated is, first of all, their doctor fills out a set form. It's called a Physician's Certificate of Medical Examination. We call it a CME, and you should all have a copy of a CME. Now, whether you use me as your lawyer or any other organization or attorney, you're going to use that same CME. So that is a really critical form that your doctor needs to fill out. Then the judge is going to evaluate that along with some other things we'll get into, and then the judge will determine if, we'll say, this child, who is now an adult, is incapacitated. So the definition of incapacity for an adult person is an adult who, because of a physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, or care for the person's own physical health. Okay, that's from the code. So that's, do you need a guardianship? That's sort of where you want to start. Is this my child? Is my child incapacitated? Would a judge say my child qualifies under this definition? Would a doctor say that? Okay? Let's get into this CME a little more. So this is the form, again, that you have. It's completed by a doctor who's licensed in Texas. So if you're with the military, you need to use someone with a license here in Texas. And the doctor fills out the proposed ward. That's the person who needs the guardianship. By the way, that's not a great term. There's a big push to change that terminology, so we're not saying ward. It's just not very flattering, but that's what that means on this form. It's the person who needs the guardianship. So their physical condition, their mental condition, the doctor writes the diagnosis. I've just highlighted a few portions of the CME. You can look at the full thing, but what that doctor says is really critical, so be aware of that form. Guardianship of the estate, this is when you have a court-appointed guardian who's responsible to manage the assets. You'll hear a lot of times about conservatorship. In other states, that's usually what it's called. In Texas, we call it guardianship of the estate, okay? How long does this whole process take? If you know you need a guardianship, how long are you looking at to get it done? It depends. It varies a lot, but I would say you need to plan at least 2 months and probably 4. Occasionally, it does go on, and sometimes different things can slow it way down. There are cases where we are in a guardianship process for a year. That's pretty rare, but I would say, you know, plan on 4 months, maybe allow up to 6, but that's sort of my best estimate based on the court system. When I say I can't totally tell you a time, there's a lot of factors such as an attorney ad litem who will be appointed to your case. We can't control how quickly the attorney ad litem goes and visits. Sometimes there are certain people who have to be notified of the guardianship and it's hard to track them down. Sometimes the court investigator is very booked up and behind and takes a while. So it just, oh, in fact, this slide says guardianship steps. There are just things that can slow it down. So if you think you're gonna need a guardianship, don't wait until your child is 18. Now, do you have to have the guardianship the day they turn 18? No, you don't. But if your situation is such that you're eager to get that guardianship as soon as possible, then I would say plan on starting the process maybe 6 months ahead of time, okay? The form, by the way, the physician's CME, once you have the doctor complete that, it has to be submitted the application has to be submitted within 120 days. So this is not something where if your child is 16, you go out and have the doctor sign the form and sit on it. You're gonna need to get the form re-signed so that you're filing the application within 120 days of the date of the form. Does that make sense? Okay, you also, let's go over these steps a little more. So After you file your application, a process server is going to serve your child. And I realize we have grandchildren here. We're just going to say child to make it easy. So a process server will come to your house and hand your child paperwork that says you've been sued, basically, which means there's someone who wants to get guardianship of you. Now, I know a lot of my parents are like, this is crazy, you know, my child won't even understand this paperwork. The way it makes sense is if you think about the reason we have most guardianships in Texas. Most of our guardianships are created because there's somebody elderly who maybe has dementia, Alzheimer's, or some reason where they can't manage their money anymore, or they're making poor decisions for themselves. That's what almost all of the guardianship cases are. Even though my world is with all of you, that's most of the work I do, but in the court system, it's mostly elderly people. So there's a lot of protections in place for that elderly person, because after all, if I get older, go a little senile, I don't want someone coming in and just becoming my guardian and taking all my money or whatever. I shouldn't say, I mean, I don't think that would happen. My kids are wonderful, but you get what I'm saying. So there's a lot of protections to make sure that the individual who's going to be under guardianship has some court oversight, okay? So that's why your child has to be served by the process server. You will have to, if you're applying to be a guardian, you will have to undergo a criminal background check. This is a new process just as of 2018, and where you register with JBCC, that's the Judicial Branch Certification Commission. I think I got that right. And they will run a background check on you to make sure you don't have some kind of criminal background. If you do, then you very well may not be an appropriate guardian. It kind of depends on what your issue is. And we have had some guardians appointed who maybe had a little criminal issue, 20, 30 years ago. They've been good ever since. But if there's any kind of abuse of a child or something like that, then of course you're probably not the best choice for a guardian. Parents are going to have the automatic first entitlement, so it makes sense. If you're a parent, the judge is going to look to you first to be a guardian. If there's not an appropriate parent, then we start going to other family members. And it can go out to county programs, but for this room, for this audience, I think we're looking at parents. Parents can be co-guardians if you're married, okay? So if you are still married, it's no more expensive for both of you to become co-guardians. It's the same price, and I recommend it. If you're divorced, you're going to have to work together to figure out who the better guardian is, and sometimes that involves a little bit of a bickering, and hopefully you can just resolve that and save a lot of money rather than fighting it out in the courts. Okay, as I mentioned, an attorney ad litem will be appointed to the guardianship case. This is a random person. You don't get to pick who the attorney ad litem is. So that attorney who's assigned will represent your child, represent the person who needs a guardianship. And so that attorney, and I get chosen as an attorney ad litem on different cases too. I just get an email from the court that says, Allison, you're attorney ad litem on this case, or guardian ad litem on this case. So this person didn't sign up for it. They'll just get notified that they should go investigate this, and they'll come meet your child, and they are supposed to represent whatever your child wants. They represent your child. They represent their wishes. So if your child says, I don't want a guardianship, then they're supposed to tell the judge, no guardianship, we don't want a guardianship. Now, I have yet to have a child really mess up a guardianship, but I suppose it could happen. I think in a lot of our cases, our children aren't going to be really able to, give a lot of advice or counsel or really, explain what they do and don't want. So the attorney ad litem just does the best they can. But if your child has some specific concerns, like I want to always have the right to do this or that, they should tell the attorney ad litem. The attorney ad litem will represent them. Now, if it turns out that there's a little bit of a fight, like maybe biological mom wants to be the guardian, divorced, and biological dad also wants to be the guardian, then sometimes we can have a guardian ad litem involved. The guardian ad litem is kind of the neutral party. Guardian ad litems are involved also when, say, the child says, I don't want a guardian, but maybe we need someone neutral to say guardianship is necessary. That seldom applies in this type of situation. So I will tell you, for most of you, you'll never need a guardian ad litem. Okay, besides the attorney ad litem, we have a court investigator, at least if you're here in Bexar County. Some of the surrounding counties do not have court investigators, but in Bexar County you do. How many of you are from counties other than Bexar County? Okay, so a little bit. So for most of you, you're gonna have a court investigator. We have a brand new judge in both courtrooms in Bexar County. We have 2 probate courts, and judges are new in both courts, so everyone is new pretty much in their roles. There are some that are still there, but anyway, so the system is kind of new. They're a little backlogged right now making the transition. So that sometimes will slow down the process. Sometimes the court investigator takes a while to get out to meet with you. But that's why I say, plan several months for this. And then you have the court hearing, and then you become bonded. And bonded is where you have insurance on yourself that you'll be a good guardian. And I realize this is sometimes almost offensive to parents. Again, you just have to think of it in terms of the elderly person with a big bank account. The law is there has to be insurance so that the guardian doesn't run off with the money. And by law, if you're a guardian, you have to be bonded. So in Bexar County, I can tell you it's automatic. The judges set it for the minimum bond if you're just guardian of the person. It's an $11,000 bond, which is a strange number, but that is the highest amount of insurance you can buy for the cheapest premium. Does that make sense? So the cost is $100 every year or $375 for a one-time fee. So if you're in Bexar County, that bond is either going to be every year you have to pay $100 or you pay $375 one time. Okay? Some of the smaller counties surrounding us, some of them don't require a corporate bond, but they will allow you to have a personal surety bond. But for most people, you're looking at that corporate bond. Okay? What do I need to do to renew guardianship letters each year? This is an important thing about guardianship. Once you get the guardianship, it is not indefinite. Your letters expire after 16 months. And so the 16-month number is, you're supposed to think of it as expiring every year. You got a few month overlap because sometimes it takes a while for new letters to be, processed and sent to you. So every year you're going to have to fill out an annual report. If you're in Bexar County, the forms are online. I can send you one. It's very simple. It will cost you just $10 to fill out the report. And then if you need to renew your bond, you'll have to pay that $100. And then for every new letter, you pay $2 a letter. So the first time you go through this system, it takes a long time, it's expensive. After that, you will have to do some renewals, but you're looking at less than $20 a year, okay? But if you don't do it, your letters expire, okay? And so you can get them caught up, but you don't want that to happen, all right? There will also be a court visitor who comes to your home every year. I will be honest, in the past that hasn't happened regularly. I think the judges now are trying to make that more consistent, and so someone should come visit you. It's not an inspection, but it's just to check on your child to make sure he or she has what they need, they're in a good place. And honestly, the way I see it, this is a really good thing because we're not going to be around forever. And when we're gone, we want someone to go check in and lay eyes on our children to make sure they're in a good place. So that's just part of it, okay? What happens if you move? If you become a guardian in Bexar County and you move from Bexar County, you need to move your guardianship, okay? It is run by the county. So it's not a difficult process. You won't have to go through all the medical qualification with the doctor again, but you do need to transfer it to another county, okay? If you're coming from another county and you have guardianship or another state, then you need to move your guardianship to Bexar County or whatever county you're living in. Okay, why is it so expensive? I've alluded to this a little bit with the bond, but let's go over it. It is extremely expensive. And since there is a recording on, I'm not going to talk about specific fees. Remind me after we turn this off and I'll get much more specific with you. But I will tell you, generally speaking, a guardianship is going to cost you, if it's guardianship of the person, you're looking at around $3,000. That's kind of minimum fee. Now, there are many attorneys that will charge you much more, but realistically, if you're a lot more than that, you should call me or someone else. But let me explain why. You're not only paying the attorney's fees, but just to file it, get it going in Bexar County, since most of you are Bexar County, you're looking at $281 just to file it and get it started. The process server is going to charge another $75. The background check, you're probably not going to have to pay for that unless you need to be fingerprinted, unless a guardian's out of state or it's guardian of the estate. But for most of you, you won't have to pay that. Attorney ad litem. Even though the court is going to assign your child his or her own attorney, you have to pay for it. You know, how much is that? It depends on the attorney ad litem, but most of the time you're looking at $500 to $700, $800. And Bexar County, well, I'll go into more specifics on the fees when we're not recording, but you see how it's hard, I can't give you a set amount until we see how that all comes out. And then the bond, as I mentioned, $100 every year or $375 for a one-time fee. And then the reports are not expensive. So, but again, to get it going, you're looking at about $3,000. So it is not something you enter into lightly, and it is expensive. And that's if it's guardian of the person. If it's guardianship of the estate, it's going to be more than that, okay? So to get a guardianship, we have to always have considered all the alternatives. Guardianship is sort of the last resort, and it should be. And let's talk about that for a minute. When our children are under a guardianship, they lose a lot of their rights. So it's not something we want to do lightly, okay? Typically speaking, a full guardianship, your child will not have the right to marry, to choose where they live, to make their own medical decisions, to vote, to drive, you know, all those basic rights. Now, for a lot of our kids, that's what we need, is we want to make sure that we have the right to make those decisions. But it's a pretty significant step because you're taking away those rights. So we want to make sure there's not an easier way to help our kids other than a guardianship. So that's an alternative, a less restrictive alternative. So guardianship of the person alternatives are, and there's many, but these are sort of the top ones: medical power of attorney, a supported decision-making agreement, a guardianship with limited authority. Okay, so let's talk about a few of those. Medical power of attorney, you're familiar with this. This is where, and all of us should have a medical power of attorney. This is where we say, if I become incapacitated, this is who I want to make medical decisions for me. Okay, so our children can also have that document where they just say, if I become incapacitated, I want mom or I want dad to make my medical decisions. Now, the thing to remember about a medical power of attorney, it's a very simple document. It's not complicated. It's very inexpensive. So, you know, it's gonna save a lot of money, but your child has to understand that document. So if your child has a very low IQ or just not a very clear understanding of the document, they can't sign a medical power of attorney because they don't have the capacity to sign it. So what I would say is Google Texas medical power of attorney. There's a statutory form that I use. I don't change the medical power of attorney. I use the one in the estates code. And look at that, show it to your child. If your child can understand that and choose who they want, then that's gonna be a much less expensive alternative for you. If that's not gonna work for your child, then that's just not an option, okay? Supported decision-making agreement. This is kind of a new thing in the last few years, and Texas actually is the first state to pass a supported decision-making agreement act to have these, which is great because Texas is usually not on the front end of these things. Honestly, I think we were so far behind on other things when we did some reforms, we got ahead on this. But it's a great idea. What a supported decision-making agreement does is it lets our children say who they want to have help them make decisions. So this is critical to understand. A supported decision-making agreement does not give you as a parent or a grandparent the right to make decisions for your child, okay, or grandchild. It lets you help them. So that means you could go to the ARD meetings. You could sit in with the doctor and you can give your counsel and advice and help explain, but you don't have any legal rights to make the decision. So, and I love these philosophically. I love the idea that our kids are keeping as many rights as possible, but practically you've got to really think about this and make sure it will work with your child. For example, if your child does become incapacitated, say they need a surgery. My daughter needed a pretty significant surgery. She has myasthenia gravis, and there was a surgery that might help her condition and it might not. Okay, if the doctor felt like she didn't have the ability to consent to that surgery, a supported decision-making agreement, I can give her counsel, but if he's not comfortable that she has the ability to consent, I don't have any legal right to consent with just that document. Does that make sense? If she wants to if she wants to sign a lease, a contract, I can't sign it for her. I can just give her advice. So if your child has very low capacity, don't rely on this, okay? Even though this is gonna be a much easier document for your kids to understand, it's not gonna give someone the legal authority to make decisions. Does that make sense? So this is kind of a sample. By the way, one great thing about supported decision-making agreements, you don't need a lawyer. You know, we talk about these expensive guardianships. This is free. You can go to the Arc of Texas website, look on there, they've got sample forms. You don't even need a lawyer for this. You know, get it notarized. You can come to a lawyer, but I'm just telling you, I'm not gonna make it much fancier than what you can already get online. So that's great. But you know, you want to fill this out and your child can say, I need help on this, I need help on that. But again, it's just giving you the ability to counsel your child, not make decisions for them. So I usually tell my parents who want to use these, if you're going to have a supported decision-making agreement, have a power of attorney to back it up. So we're going to get into financial powers of attorney. In other words, the financial power of attorney, you can choose whether or not it's effective immediately or upon incapacity. So what I usually recommend is if you're going to do a supported decision-making agreement, have your child also sign a financial power of attorney or a general power of attorney that kicks in upon their incapacity. Does that make sense? So at least there's somebody who could make decisions. Because again, if you don't have that and all of a sudden you're in a situation where a decision needs to be made, maybe it's an emergency type of situation, then you are looking at a guardianship. And if it really needs to be rushed to where you get a temporary guardianship, that gets much more expensive. So you don't want to deal with that if you can help it. Okay. Guardianship of limited authority. Again, we're talking about alternatives to this full guardianship. So this is still a guardianship. It's not going to be any cheaper, but it doesn't take away as many rights. So this is where you work with a doctor and you say, you know, my child needs help with this and this, but he or she really wants to keep this right. Okay, for example, my daughter who's 25, she loves to vote. She loves that sticker. Now, does she really understand politics? No. But she loves putting that sticker on, taking a picture, and telling everyone I voted. And so if I were to get a guardianship for my daughter, which I don't have one right now, I would talk to the doctor and say, let's let her keep her right to vote. I really think it's important to her. She can understand as much as some of the other people. Please, you know, let's let her keep that right. You know, marriage is another one. Do you want your child to be able to make a decision about marriage? And by the way, on this topic, my daughter, who's 25, she has her first boyfriend, and she got her first kiss. And I will say she's becoming more and more independent. I'm so proud of her. But it's interesting, the more independent she becomes, the more I'm actually leaning towards a guardianship, because it is scary. It is really scary. If my daughter could just run out and get married, it is a terrifying thought to me, even though I really like the guy, he's great. But so, you know, this is a tough decision. Like I said, I go back and forth. I don't have a guardianship of my daughter yet. As I watch her grow and become independent, I'm actually reconsidering a lot of things. And so there's no right or wrong answer for you. Do you need a guardianship? It's going to be very, very individual. But you know, if you want to come into my office sometime and just talk through your specifics, I'm happy to go through the different pros and cons and with you, because it is a big decision for some of us. For some of you, it's going to be very clear. You need a guardianship. There's no question about it. But for some of us, it's a closer call. Okay, but if you want to do a guardianship with limited authority, then you want to work with the doctor and have the doctor agree with you, because how the doctor fills out this form is going to be more controlling than what you tell the judge you want. So I could go in and say, I really want my daughter to be able to drive. It's a big deal to her. And by the way, she's not going to drive. She doesn't want to drive. But let's just use that as an example. She really wants to drive, judge. Well, if the doctor says, she should not keep the right to drive, judge is probably not giving it to me. So if you think there are some rights, and this is why you want to become familiar with that form, if there are some rights included that you want your child to keep, work with the doctor, make sure the doctor agrees and fills out the form that way. And then you work with your attorney and you can do a guardianship with limited authority. Does that make sense? Okay. But you'll notice here, otherwise, we'll just keep going. This is where the doctor states which rights you can keep and which ones you can't. I guess just look at your form. This is hard to see. Okay. Guardianship of the estate. So this again is the guardianship where you're managing money for your child. This, I really submit for most of us, we can find an alternative to this one. Sometimes we can't get an alternative to the guardianship of the person, but this one we usually can, if you plan ahead, okay? One alternative is the supported decision-making agreement. We've already talked about supported decision-making agreements. There's gonna be something in that agreement that says, help me manage, or give me counsel, help me make decisions about my property. So help me manage my property by counseling me. Again, it's just, you don't have the right to make the decision, but that is an alternative. That might be enough that maybe your child is capable of managing money with a little bit of help. Durable power of attorney. Okay, we talked about medical power of attorney. This is a durable power of attorney. So in Texas, we have a statutory form, which I will use the statutory form, and then we can add some extra powers. So depending on your child, if they're still in school, I'm going to add a bunch of extra language about, going to the ARD meetings and helping make IEP goals and all that kind of stuff. So depending on your situation, I'll add some extra powers. But otherwise, you will use the statutory form. Now, you could Google Texas statutory durable power of attorney, and you can see the Texas form. And honestly, you could print it out and hand it to your child. That would be a durable power of attorney. Let me caution you against that, because this is a common approach for many parents. If you don't have it executed in an attorney's office, you're very likely, depending on how you're trying to use it, it very well may be rejected. Okay? Just because your child signs it does not necessarily mean it will be accepted. So if you've done that route, you need to give it to the organizations, the school or whoever, make sure they'll take it. Usually the school is fine with that. It kind of depends on your school district. But anything involving money or a major decision, if there's borderline capacity, they're gonna, a bank, they're gonna be nervous. So I think since powers of attorney are not expensive, my strong recommendation is just do this in an attorney's office, because if I'm the attorney, I have to vouch for the capacity of the person who signed it. And I'll be honest with you, I've had to tell several parents, I'm sorry, I just feel like your child does not understand this. And it kind of breaks my heart to say, in my opinion, they need a guardianship because they're not understanding what we're doing. But if I do let them sign it, I feel confident enough as an attorney that they have the capacity to understand. And then when you use that, I'll back it up. Does that make sense? Whoever's not comfortable with it can call me and I'll say, oh, no, we went over it, they understand it. So again, I think it's worth it to use a lawyer, but it's not gonna be that different. Now for all of you, while we're on powers of attorney, this is not your child, because all of us should have wills and powers of attorney and everything. I will just mention, if I were to do a power of attorney for everyone in this room, I would add quite a few extra powers, and we're not going to really have time to get into the details, but I'll give you one example. As you get older, if you ever needed to go into a nursing home and needed to get on Medicaid yourself to cover the nursing home costs, you have to be pretty poor to qualify for that nursing home coverage through Medicaid. And typically what happens is a family spends down the money until you're below $2,000. There's a few tricks we can do. I shouldn't say it that way, especially recorded, but there's some things we can do to save about half your assets, but you have to spend them down. However, if you have a child with special needs and they have a special needs trust, you can give that money to the trust and qualify immediately. And so there are some things like that I would talk to you and say, do you want to, in your power of attorney, to add some extra gifting provisions so that a special needs trust could be created? I'm getting a message that I'm talking too fast. Sorry about that. Okay, I'm gonna slow down. This is just an example, but there are a lot of things, if you have a child with special needs, that will wanna look at your own estate plan, will wanna look at your powers of attorney, will wanna look at your situation and see if your will needs to be edited a bit, modified, some extra provisions included. do your powers of attorney, do we want to include some extra powers in there? Okay? That's a little bit of a detour. We'll get back on and I'll slow down. Okay. Again, on the power of attorney though, before we move on, we're looking at an alternative to guardianship of the estate. Remember, your child has to have capacity. This is a tough document to understand, so look at it and see if your child would understand that. Okay. This is a great alternative to a guardianship of the estate. It's through the Social Security Administration. It's called a representative payee, or rep payee. What a rep payee is an individual who is legally authorized to manage all the Social Security funds. So SSI, SSDI. If you are the rep payee for your child, that's as good, well, in most cases, it will let you go in there and take care of everything without your child. It will let you talk on the phone, ask questions. You can open up a bank account with your name on it and your child's name on it. You can help manage all that money without a power of attorney. In fact, Social Security office doesn't take a power of attorney. Now, there are a few things where your child will have to go in and sign something, but this will cover most of it, okay? So this is a great way, because for most of us, our kids, the income they're gonna get, it's usually gonna be SSI or some other kind of Social Security disability. So without becoming representative payee, now someone has to manage this money, but becoming rep payee will let you avoid guardianship of the estate, at least for that Social Security money. Does that make sense? Okay. This is the biggie. The best way, if you want your child to have assets, so not just the income from SSI, but you want to leave them a little something so they're not living on, $771 a month. If you send it to a trust, then a trustee can manage the money. And this, I think, is almost always going to be a much better option than a guardianship of the estate. Even though you're going to have to pay money up front to have the trust created, it is going to save money after you're gone, every year, going back to court, hiring a lawyer to do the accountings, things like that. So a trust is something everyone should really consider. Let's see, and let me just say, a trust, just because you have a trust, it doesn't necessarily involve, let me back up. Just because you have a trust, it doesn't necessarily mean you don't have to have court involvement, but if you plan ahead, we can usually avoid it. So for example, if a trust is created after your child is under a guardianship, it might be that the trust needs to have court oversight, and that means accountings every year. If you leave a big inheritance to your child, and your child doesn't have much capacity, and a court needs to be involved to create a trust, then there's going to be court oversight every year after that. So if you're going to use a trust, you want to plan ahead and get it all established without the court involvement so that you save costs down the road. Does that make sense? And the best way to do this for most of us in this room is going to be a special needs trust. So let's get into that. Okay, so generally speaking, a trust, just so we're all clear. A trust is a relationship where one person holds legal title, but it's for the benefit of somebody else. So you got the beneficiary and then a trustee. There's actually, three responsibilities that are key. One is the settlor or the grantor. That's the person who sets up the trust. So that's going to be you in most cases. And then the trustee, this is the person who's going to manage all the money. And for special needs trusts, children, a lot of times it will be you as parents starting out. Maybe you'll be co-trustees. It could be a nonprofit organization like the Arc of Texas. We'll talk about trustees in more detail in a minute. But then it's for the benefit of the beneficiary. Now, a lot of people have revocable living trusts. That's a very common type of trust. That's where I could have a trust, have all my property titled in the name of the trust. I could be the trustee for myself as beneficiary. But if we're talking about a special needs trust, that is a much different trust. So if you're going to have a special needs trust created, do not just go to any lawyer and say, do you do trusts? Okay, I need a trust for my child. It has to be a very particular kind, a specific kind, a special needs trust. Otherwise, that money in there is going to count as your child's money. So what we're trying to do is we're trying to move the money into a trust that will not count as your child's money for government benefits purposes, that the court will let the trustee manage it, that kind of thing, okay? So we said that's what a trust is. The trust agreement, that's of course the big document that you come in and sign. And then the trust fund, this is a little confusing to a lot of people, but the trust fund could be a checking account, could be a savings account, could be an investment account. It could also, you could have a house and the deed could be titled in the trust. So there's lots of different types of property that could be in the trust. And so for some of the trust property, it might be just a deed that's recorded in the county records and your house is in the trust. You might have an investment account that either pays into the trust or is titled in the name of the trust. Does that make sense? Or it could be just a regular bank account. So how is a special needs trust different from another trust? We kind of alluded to this a little bit already, but a special needs trust is only available for someone who is disabled. Okay, so I can't get a special needs trust for me, you know, but your children, they're going to qualify most of the times. The stated purpose is to supplement, not supplant government benefits. So there's going to be some key language that's included in there, and this is one of the critical pieces of language, that this trust is created to add supplemental funds to what the government is already providing for our kids. But it's not replacing those government programs, okay? It's not supplanting it. A properly drafted and properly administered special needs trust will not count as an asset for our children. So they can keep qualifying for all their programs. Now, this is critical to understand. It has to be properly drafted. It cannot be, like I said, just anybody, any lawyer won't pass, because Social Security and Medicaid offices, they're gonna send it off. The Social Security Administration, for example, has a whole review team, and they're gonna go through it line by line. And if they say, oh, this isn't drafted properly, it's not a special needs trust. Okay, but after it passes the initial muster, it has to be administered properly. So you can't just get it approved and think we're good to go. You have to think, who is the trustee? Do they understand how these funds can be used? What kind of special needs trust is it? We're going to get into more detail. So for example, if you have a special needs trust and it's paying for your child, but it's also paying for everyone else in the house to go to Disneyland or something like that, it's not going to be a special needs trust, because a special needs trust has to pay for the beneficiary. You know, it's covering the person with disabilities. Does that make sense? Okay. And also, another great thing about this trust is there's no transfer penalty, which means you can leave money to a special needs trust and it won't disqualify your child from benefits because you put money in it. Does that make sense? That's an unusual thing about this kind of trust. All right. What can a special needs trust pay for? Pretty much everything, as long as it's for the benefit of the person with disabilities. Okay? Now, I get a lot of parents who say, I read that a special needs trust cannot pay for housing. There are some kinds of special needs trusts that say no food and shelter. This trust cannot pay for housing, apartment rent, anything like that. That's the way some special needs trusts are written, but not most of them. If you came to me, I'd say, let's talk about it, and we would make it a discretionary trust. The reason some attorneys put that provision in there is because if your child is on SSI and the trust helps to pay the housing costs, the SSI will be reduced by 1/3. It's called in-kind support and maintenance, which we're going to get into that too if we have time. So a lot of times these trusts are drafted to where they say, no, we're not paying for shelter. But for my trust, I think it's worth it to let the trustee have some discretion. And so with some careful drafting, we can say if it's in the beneficiary's best interest to let the trust pay for housing, let's go ahead and do it. Because I don't want my daughter living in some place that she can afford if she's only can use her SSI money. Does that make sense? I'd rather have her take a little less money and live in a nicer place. So, but there are also a lot of ways around this we're going to get into. Honestly, there's ways for the trust to send money to an ABLE account, have the ABLE account pay, no reduction. So there's lots of other options. Okay, but let's see. Pretty much though, the trust can be used for what your child needs. So if they need clothes, if they want to go on vacation, the trust can pay for it. So you're leaving the money so it can be spent. So the trustee needs, that's another reason when you think about who your trustee is, they got to understand how to use this. And you want them to use it. The last thing you want to do is leave a ton of money that just sits there and your child lives on SSI or SSDI, you know, small amounts. Okay, there are two types of special needs trusts. There's a first party trust and a third party trust. This is very important to understand, okay? So when we say special needs trust, two totally different kinds. A first party special needs trust can only be established for an individual with disabilities who is under the age of 65. So this is not for someone who becomes disabled in their, you know, elderly years. So you have to be under age 65. The trust can be established by a parent, grandparent, guardian, or a court. And recently, just the last couple of years, now we can have the individual with disabilities establish their own trust if they have capacity. The reason this is critical is because sometimes we have to have a court do it. If like there's a big, I don't know, the inheritance or something comes in and there's no parent or grandparent and the person doesn't have capacity to do their own, we have to go to court. Now it's a court-managed trust. That's why I said sometimes the court still gets involved. But assuming one of these people could establish it, then we fund it with the beneficiary's own assets. Okay, this is super important to understand. This is one of the main things to remember about a first party special needs trust. It is funded with the beneficiary's own money, their own assets, okay? So that means if you leave a bunch of money to your child in their name, you don't leave it to a trust, and now they're disqualified for their programs, they could get back on their programs, but now it's their money. See what I'm saying? It's in their name. Because it's in their name, it's their money, the only kind of special needs trust they can use is a first party trust. So if your child got a personal injury settlement, you know, they're not hurt too much maybe, but they got a little car accident and they get $40,000. It's in their name. That's their money. So the only kind of special needs trust they can use is a first party trust. Does that make sense? It has all the money in that account has to be used for their sole benefit. A first party trust is actually the very strictest type of special needs trust on this. What it means is if you're going to use this trust to pay for the cable, you better figure out how many people are in the house and only pay for your child's portion. Does that make sense? If you want to go on a vacation, unless you have really good evidence and clearance that you need a medical, parent to be there medically, maybe you could pay for the parent, but you better not pay for anybody else. So it's for their sole benefit, okay? This is also, I've put in red the things I really want you to remember. A first party trust has a Medicaid payback on it. That means if you have a first party special needs trust that is funded, when your child passes away, if there's any money left in that trust, Medicaid gets paid back for the funds that they've spent on your child over their whole lifetime in every state they've ever lived. So if I create a trust for my daughter when she's 25, they're gonna look at where did we pay for Angela? She lived in Boston, she lived in California, her whole lifetime. Did Medicaid cover anything? And they're gonna get paid back, okay? So this is a big deal. And I will say something else. For a lot of families I talk to, they say, oh, my daughter never goes to the doctor. Medicaid hasn't paid for hardly anything. If your child receives SSI, they're very likely put into a managed care program. And that means that if you're in managed care program, there's a bill every single month, whether you're going to the doctor or not. You've probably got $5-6 grand accumulated because of the cost to be in the managed care program. Once you're on these Medicaid waiver programs like HCS, CLAS, those are Medicaid programs. So all of that will be included in the Medicaid payback. Does that make sense? Okay. A third party trust, on the other hand, does not have that Medicaid payback. No Medicaid payback. It's not quite as strict on some of the other provisions. It basically, we have a lot more flexibility in how we draft it. So a third party trust, if I were drafting that for you, I would ask you some questions like, what do you want this trust to pay for? Do you want the trust to pay for a sibling to be able to fly in and see your child? So I have 4 kids. So my trust actually says the trust can pay to bring in Angela's brothers and sisters if they live out of state. Or it can fly her there. And it can pay for, so you've got a lot more flexibility on how you want the money spent. It also, you get to choose where the money goes when your child passes away. Now, going back to the first party trust, if Medicaid only had $20,000 in payback amount and you had $100,000 in there, they're only going to take $20,000. And let me also say, if there's only $20,000 left and you owe them a few $100,000, they only take what's in there. They're not going to go after the rest. But still, we want to avoid that if we can. So third-party trust, there's no Medicaid payback. So you say, when my daughter dies, it's going to go to her siblings or to charity or whatever you want, okay? So a lot of flexibility. This is the special needs trust that I would argue most of us in this room are going to want, okay? And we want to try to avoid first-party trust if possible. Sometimes we can't, and we'll get into more detail, but all of us, if we want to leave assets for our children, this is what we should be looking at to give them protection, and then you just will decide where the money goes after they're gone. Okay? A third-party special needs trust can be done as a testamentary trust or an inter vivos trust or a living trust. Testamentary just means you put it in your will. It's not in existence until you die, and then your will kicks it into existence. Inter vivos or living trust means you go ahead and establish it now, and maybe you fund it with a $10 bill. A lot of times with my clients, we'll literally tape a $10 bill to the trust. And it's funded. That doesn't mean you have to start investing or put it in, open up a bank account, but you have a trust that's funded. And if you want to, you could open up a bank account, or if grandma and grandpa want to leave money, there's a trust in existence they could leave it to. Does that make sense? So for my clients, I don't charge more or less if it's in the will or not in the will, because it's the same provisions. And my personal preference is in most circumstances, I'd say let's just pull it out and have a standalone document. And there's a lot of reasons for that. One is if you ever need to modify your will, do a codicil, you don't want an attorney charging you a fortune because they're looking at a 50-page will with this big old trust, this trust language, or, and if they need to modify the trust, you can just modify that. But the biggest reason, like I said, is that way if someone else wants to leave money, they can leave it in the trust. You can invest already. There's just a lot of good reasons to pull it out, but I've done it both ways, so it kind of depends on the situation. Okay, so we're talking about first party, third party. Why would anybody ever take the first party special needs trust when the third party trust will avoid the Medicaid payback? We kind of mentioned one reason already, which is if the money's in your child's name, or it's the only option, okay? So, for example, if your child is applying for SSI, if they have money in their name, you can move it to a first-party trust in most cases, but it has to be a first-party trust because the money's in their name. So, for example, if you have a 529 plan, or you have an educational trust fund set up in your child's name, or maybe they have a life insurance policy with a cash value, if you have to cash that out to qualify for a government program, now it's their money. Okay, if you have an educational fund, I have parents all the time that have stocks and bonds that, they wanted to provide for their children, and then they go to apply for SSI and they realize, I can't have all these assets. Well, what we usually have to do is we have to cash them out, but now the money is your child's money. So we can only use a first party trust to get them qualified, okay? Also, if there's an inheritance, and this, I want everyone to pay real good attention to this. If they receive something, if your will says everything to my spouse, if my spouse isn't alive, to my children, and then you pass away, once you die, if there's not a spouse, that takes the money, if it goes to the children, that's in their name. Now, this first party trust is the only trust you can use. Does that make sense?
So,
yes.
When you set up your life insurance policy, you need to only have the trust, the SNI, special needs trust established, so you can put the number, so it goes directly to the trust.
Yes, so the comment was, when you have a life insurance policy, you need to really look at the designated beneficiary, and that is absolutely accurate. So think about this. If your life insurance policy says, to my spouse, and there's no contingent beneficiary, if your spouse is not around, it will go to your estate. That's the default. If it goes to your estate, we're going to look at your will. Whatever your will says is going to control. If you have no will, the state of Texas is going to decide. And it's probably going to be who you want. Sometimes it's not if you've got prior marriages. We can talk about that later. But it's going to, but it's not going to go to a trust. So if you want to have it go to the trust, then you can designate your estate as long as your will has already taken care of it for you and assigned everything to the trust. Otherwise, you could say to my husband first, if he's not alive, to the trustee of the Angela Pakard Supplemental Needs Trust, established on, July 15, 2019, something like that. So you're exactly right. So you've got to think about all of your assets, what could pass to your child with special needs. 401k, individual retirement account, life insurance, a bank account if there's a payable on death, or any kind of stocks, anything with a transfer on death. But look at those assets and think, what would go to my child potentially? And if you have it all going to a spouse, what if your spouse passes away with you or passes away before you? So think about those things, because you're exactly right. If you don't have it named, the named beneficiary as the third party special needs trust, you're going to be looking at a first party special needs trust most of the time. Okay?
So that's like you're saying, when your clients open up a trust for $10, like it's just opened, even though nothing's in it. But so things like that happen, it's open if you're already directed.
Yeah, so the question is that why I tell my clients to open it with $10? Yes and no. You can actually name a testamentary trust. So you don't have to have a living trust. You could name a testamentary trust as a designated beneficiary on a life insurance policy or something. That would work. Yes. That's one of the reasons I love to have an account open, though, is because then you can say, okay, life insurance company, this is the first name beneficiary. The second one is the trustee of the Angela Pakard Special Needs Trust, dated, and give the date. So you're exactly right. Okay, everyone's with me? I see some people like, oh, we're good? Okay. Another reason to use a first party trust. There are some sources of income that have to go to a first party trust by law. One of those is military survivor benefit plan annuity payments. So if you are in the military, talk to me later, because there's a lot of other things I would typically cover with you. But if you're leaving SBP for your child, which is a great benefit, by law, it has to be assigned to a first party trust. It used to be it couldn't be assigned to any trust. But now we have the option to go to a trust, but it has to be first party trust. Child support. If your child is going to get lifetime child support, then it has to be irrevocably assigned to a first party trust. So there are just certain things by law that have to go to first party trust, but otherwise we try to send it all to the third party trust. Okay? All right. I just have this slide up there to remind you that there are a lot of programs that are mean tested government benefits, where you have to have limited income and limited assets. So if your child is going to be on the class program, or might get, Section 8 housing, or have SSI, any of these programs, you're gonna always need very limited income and limited assets. You definitely are gonna want a special needs trust in the picture if you're looking at these programs, okay? We're gonna talk more about that when we talk about SSI. All right. So this is kind of just a general benefits of special needs trusts. One of the great benefits we haven't really talked about is you have someone to manage the money. So sometimes we do a special needs trust even when we don't have a government program we're trying to protect, but parents just feel like we need someone to manage the money, and in case a government program comes along, we draft it as a special needs trust. It also protects our kids from creditors or from someone who might try to take advantage of them. I mean, I'll be honest with you, that's one of my biggest fears. If my daughter has any money, I don't want someone taking advantage of her. She wouldn't have a clue. She'd give away her money in a heartbeat. Or someone could marry your child and they have legal rights to that money. So there's some creditor protection and other kinds of protections. As we mentioned, it can avoid the guardianship of the estate in some situations. Gives supplemental funds. I think we've covered the rest. Okay. Who can be the trustee? Let's talk about that. This is a really big decision. All right, because as I mentioned, the trustee has to know how to manage this trust. So whoever you choose to be the trustee, they have to be willing to learn about government programs. They need to understand, all right, what program is Angela Pakard on? Is, you know, if I use the trust to pay for this, what will happen to her SSI? Oh, is she on SSDI? You know, you got to figure out there's difference on different programs. I would say, generally speaking, you know, there's no set right or wrong answer on who the right trustee is. I would say, generally speaking, most of my clients, I have the parents as co-trustees to start. That way you have a lot of rights. If one of you dies, the other one continues as sole trustee. A lot of times the trust isn't really funded till you're both gone, but it makes sense because of some other rights you have to modify the trust, control who follows you, just, you know, so typically we'll have parents as co-trustees. Then it's after you're gone, this is where it gets tough. The most common idea is we're gonna have the sibling do it. And, you know, my daughter, as I mentioned, has 3 siblings. I could have her brother step in, the oldest boy. He could be the trustee after we're gone. And I'll use my son as an example. He's a great kid, but I'll just tell you, these are the things that go wrong. So these are the things you gotta think about. If my son is the trustee, every dollar he spends from this trust money is less money that's gonna come to his pocket down the road, okay? Because he's gonna get it when my daughter's gone. So in some situations, the siblings have a little bit of a conflict of interest because they know if I'm spending this money, it's not gonna come to me when my sibling is deceased. And I'll be honest with you, it's usually not the sibling, it's the in-laws. You know, so I say that kind of half joking, and my son is married, he's got a wonderful wife, and I totally trust them. But, you know, you think about these things like, do you really know who that sibling's gonna marry? Because this is what I hear, and admittedly, I hear all the bad stories, okay? Nobody comes and sees me and said, our trust is going great, everybody's happy. You know, they come see me when things are wrong, but this is the common thing I hear. You know, well, she said, oh, honey, if your mom and dad were alive, they would know that we need this van way more than your sister needs that money sitting in her trust. Your parents would want us to go to buy this car, you know, and then they take it, and let's be realistic, it's illegal. The trust has to be spent on our child with disabilities, but how many of our children would know if money was taken from their account? My daughter wouldn't have a clue. So if my son decided to go buy a car, yeah, I mean, if he got caught down the road, we could do all kinds of things, but honestly, that money's gonna be gone and my daughter would never know. So every day, people steal from special needs trust. Now, I don't mean to sound so negative, but these are the things you need to think about. And another thing you wanna think about before naming a sibling is that sibling gonna really have the same commitment you do to figure out all these government programs? Because if that sibling just writes out a check, you know, if Brent, my son, said, okay, Angela, you need $200, here's $200 from your trust. Well, she has to report that income to Medicaid, she has to report it to Social Security if she's on SSI. I mean, you can't just give away cash, and you gotta figure out what it pays for. So for some of our kids, that's a pretty heavy burden to put on them to learn all this stuff. So I generally say a starting point would be try to avoid a sibling if you can. That being said, I will be honest with you, I have my other daughter named as a successor to me, so I'm not totally against it. But my other daughter, she's gonna go to law school, this is what she wants to do. Now she's not married yet. When she gets married, I may change my mind, you know, depending who she marries. But, so I don't wanna say family members are never the right choice. But you know, these are the kinds of things you wanna think about. Now, if you're going with a non-family member, you want someone neutral doing it. If you're leaving quite a bit of money, there's a lot of assets to work with, then a bank is often a great choice. But you don't want to just go to any bank. So you don't want to just use your bank that you use automatically, because if you talk to your bank and say, will you be trustee of a trust? Most of them are going to say, absolutely. That's different than, are you ever trustee for a special needs trust? How many special needs trusts do you have? Because remember, bank trustees, they're really good at growing the money. They know how to invest it. They know how to give you a report saying how much it grew. But that doesn't mean they're gonna go check on your child, see what does your child need. They're gonna wait for someone to come to them and ask for a disbursement. So you wanna go with, if you're gonna use a bank, you wanna go with a bank that does special needs trust. You want to meet with them, kind of figure out, you know, what's your program, what do you do, if you were to come to me and say, I think I want to go with the bank, I would probably give you 4 or 5 recommendations. And if you have the time, I'd say go meet with them. They don't charge you. See who you're comfortable with. And then the reality is, you know, the life we live, you're probably going to have to reevaluate this 10 years, 20 years. Because the best choice of a bank trustee today may not be the best choice 10 years from now, which is why I want to give you lots of rights to make changes to this trust if you can, okay? The first party trust is irrevocable. Can't make a lot of changes. Third party trust can be irrevocable. Typically we draft them revocable, so it's real easy to change all kinds of things on it, okay? So again, if you were choosing a bank, you meet with somebody, you pick somebody. If you were elderly and had stage 4 cancer, I know exactly who I'd recommend because there's a trustee in town that is phenomenal. But she's my age. So for most of you in this room, she's probably not going to be the trustee for that particular bank down the road. So, you know, we just kind of look at options. Now, how much, I say you have to be leaving a lot of money. Banks don't, these banks that have these special needs trust programs, they won't just take any special needs trust. There has to be enough money in the trust account that they can invest it and grow it to pay their fees, because banks are going to charge fees. Typically the fees are going to be anywhere from 1.2 to 1.5%. That's generally what I see. And so they want to grow the money to cover their fees so they're not dipping into this trust account. So for most of the banks that have really great programs, they usually want about $400,000 or $500,000 to work with. A lot of my clients don't have near that kind of money to leave to their kids. Now, that could include a house. You know, it could include some retirement accounts. It could include some other things. But you know, if you're not leaving, there is one bank that's pretty good. They have a great program, and I think they take $250,000. But that's something to consider. If you don't have that kind of money to leave to your child, which I'll be honest, most of my clients don't, then another great option is a nonprofit organization like the Arc of Texas. The Arc of Texas has a master pooled trust. When I say the Arc of Texas, this is not the Arc of San Antonio. It is the Arc of Texas, so this is run out of Austin. They have a master pool trust, and they will be the trustee for, you could, you know, leave $10,000 and they'll take it, any amount of money. Now, they also charge fees. Let me just make that clear. They're not doing it for free, even though they're a nonprofit, of course, but it's called a pooled trust, and they will pool your money with everyone else's. And their fees are anywhere from 1.25 to 1.75%. So the percentage is not really lower, it's just they'll take any amount of money. So we'll move off of this, but I guess what I'm saying is that is a big decision if you're going to create a trust. Who is going to be the trustee, at least to follow you when you're both gone, okay? Oh, and I don't want to forget this. We mentioned revocable living trust. I could be the trustee of my own revocable living trust. Of course, the special needs trust beneficiary cannot be the trustee. That is critical for special needs trust. They cannot have power over the trust. So my daughter Angela could never go into the bank and say, hey, I need to take out a couple $100. They would say, I'm sorry, this is a special needs trust. You have no authority, it has to be the trustee. Okay? All right, I kind of already mentioned this, a pooled trust, that's called a C trust. We sometimes refer to it. This is where you have a nonprofit organization manage the money. A nonprofit like the Arc of Texas, they will do a first party trust or a third party trust. They do both. It doesn't have to be the Arc of Texas, they're just a really particularly good one, but there's national ones. You know, if you were gonna move out of Texas, I'd probably connect you with a more national organization, but anyway, they're great though, Arc of Texas. Okay, I just want to emphasize this. If you have a trustee, remember that does not replace the guardianship. I have parents get confused on this all the time. Remember, a trustee is managing money. So the trustee, if you have a special needs trust, that doesn't give them the right to make medical decisions, to sign housing contracts. It's just going to replace the guardianship of the estate. Okay? All right, are you all, we're going to talk about ABLE accounts. Everyone's good? 4 minutes? Take a break. Okay, we're going to take a break and then we're going to talk about ABLE accounts. Okay, we're going to take a 4 or 5 minute break. Okay. All right. Everyone stretch. So far good, huh? Any general questions, anybody? Or specific?
Well, talking about guardianship, And you said the medical document, 120 days between that and the application. How soon can you file the application as your child's approaching the age of 18?
Yeah, it kind of depends on the court, but most courts, I'd say 6 months ahead. That's what I do. And I'll file it 6 months as long as the parents know. It might sit there for a couple of months. We hope it's all ready to go.
I don't want to start the process because she's 6 months is when she'll turn 18.
Yeah, okay, then I do it now. Okay. And I didn't mention this, you can't have the hearing until your child's 18. So
Right.
it will just sit there until they're 18 and then you have the hearing. But yeah, I'd say, I mean, you don't have to do it 6 months in advance, but that way there's plenty of time for the attorney ad litem to be a slacker, for your background check to get held up.
It could take a long period of time. How soon can I get it started? Just in
Yeah.
case it does, so we're not waiting after. But okay,
Yeah,
that's what I wanted to know.
I'd do that. And are we recording now or are we paused? But you're not going to include this part? Okay, I will tell you since we're off the camera. Don't include this. The cost is going to be about $3,000, like I said. That's about as cheap as you can do it if you work. If you don't work, then, and I say don't work, if you're living below the poverty line, then you can get some court costs waived, but you have to be pretty poor. If you could go to Catholic Charities and they will do a sliding scale payment. But even if you use Catholic Charities, it starts at $850. So you could have zero income and you still pay $850. But the court costs can be waived if you have very, very limited income. So like if you're just getting some Social Security, sometimes we can waive court costs. What I usually do is if I'm not too busy, I will match what Catholic Charities will do on the poor end. If I'm like overwhelmed with guardianships, I'll just say, just go to Catholic Charities. But sometimes it takes a while. But if you're working, I charge the same thing as Catholic Charities for this group. Like if you were to come to me and you had an elderly person who needed a guardianship, I would not charge my fees. My fees are $2,000. And like I said, if you pay, if it's for a child with special needs and it's guardian of the person, I would charge $2,000. You're going to have about another $1,000 in all those other court costs. So it's going to be about $3,000. That's the same thing as Catholic Charities, which they're great. I do some volunteer work for them, but that's where we are. But it has to be you. So if it's like I said, an elderly person calls or you called my office, they would probably give you a higher price, but that's what I charge every one of my families. Again, if you have very limited income, then you can sometimes get those court costs waived, but you still have to have money. There's no free guardianship program out there. Everybody, if you need a guardianship of the person, it's going to cost minimum of $850 with Catholic Charities, even if you have no income. Okay? So the trust, let me just cover that while we're off too. My special needs trust, because everyone always like, how much money are we talking? I will charge for families like yours $2,000 for a special needs trust. My standard fee is $3 if you call, but if it's a parent or grandparent, I charge $2. If you need more than one trust, I max it out at $3. Like I don't charge full price. Like sometimes people have 2 kids, or sometimes you need a first party trust and a third party trust. For my families like this, I typically will max out everything at $3 because it's an expensive thing, you know. So a will, you will want to update your will. My standard fee for a will is $500. If you're already getting a trust, I'll charge you half price, you know. And so you're probably looking at about $2,500. Sometimes I'll just do powers of attorney just to throw them in there. But you know, you're looking at, that's kind of my range. I'm never offended if you want to come talk to me and you want to look around. I actually am much lower than most people, so it doesn't bother me. I'm not offended. I would ask around. So I don't mind, but if you ever just want to come talk about it, I'm not picky about like, oh, you came in and saw me, how come you haven't called me back? I'm actually really not. So if you just kind of need a sit down, you know, I'm not going to pressure you like, hey, how come you didn't, you know, come back in? That's fine, you know. Okay, someone else had a question. Any other question on fees while we're kind of off the camera?
I was going to ask, can you share the slides with us?
Yeah, if you send me an email, I'm happy to. Yeah. Did you have a question?
Yeah. When you started off talking about trust, you said you need to do it before you get guardianship.
Oh, that's a really good point. Yeah. Okay.
Let me finish the
Yeah.
question. I already have guardianship, co-guardianship for a child. So do I need to let that lapse, set the trust, and then go for full guardianship as an adult?
No. Okay. Oh, well, okay. Okay, yeah. So guardianship of the child is not the same as the guardianship in the court system. So you're not, even though you're, well, it is because you're in the court system.
I'm in the court
It's not the
system
same as the probate court. This is going to be a whole new procedure. Yeah. Okay, so the question is, what if I already have guardianship, or how's the timing with the guardianship? If you are guardian of the person, and then your child needs a special needs trust, if it's managing their money, the court's gonna be involved. If you're already the guardian, you're gonna have to go ask the judge, hey, she got all this money, can we just create a trust? And you can create a trust, but unfortunately, most of the time now the court's involved from then on. If it's like planning to give money down the road, there is no money right now that the child owns, you don't need to involve the court in that. So if you just want to leave your inheritance to your child, even if you're already guardian, you can set up a third-party trust. Does that make sense? Yes. So, but if your child got an inheritance and you were the guardian, like grandma left something, and you're already the court-appointed guardian, then you're going to usually have to involve the judge, and unfortunately, then you're looking at probably annual accountings, things like that. That's a good question.
Thank you.
Yeah. Other questions?
Question about the fees for guardianship. You said if they move from one county to another, would that entail like a whole 3,000?
Yeah, no, did y'all hear that? The question is like, what if you have to move and change your guardianship? It's not going to be as expensive. It kind of depends on the lawyer you go to. There are going to be court costs, usually filing fees again, but you're not going to have all the medical evidence. So I would guess for most lawyers, you're looking at no more than half of that. But if they're charging you 3 or 4, go find another lawyer. Yeah. But it just kind of depends where you're going and what you need to do. The biggest expense when we get guardianships coming from out of state is we have to have a certified copy of their record. And sometimes we spend a fortune just getting certified copies. Yeah. Did you have a question?
Maybe my son just turned 18 in June, and I had to add him on the list, but I don't have anything. So I was just telling him, okay, you go sign here and sign that. So it's still a legal binding with him.
As long as someone says they have capacity, then it's going to be legally binding.
Okay.
Does that make sense?
He didn't understand what he was signing.
If he signed something, he didn't understand it, then legally it's probably void. Will someone take it? It just kind of depends. It's a good question. Yeah, just depends if they want to take it.
I mean, he's under the class program right now, but I'm a single mom. I work and I'm so busy at work that I forgot to renew his Medicaid. So he's not gonna have it for the month of August, I believe they said, until we apply. Is he gonna lose some of his class?
I think you'll probably be okay, but you'd have to just talk to them. If it just lapsed for a month, they'll probably get it back. You'll probably be okay. Yeah, but I talk to them. Okay. Are you about ready? Yes.
Even though, we don't need a trust now, did you say you'd advise everybody to start a trust?
I would, because you don't want to risk having a first party trust.
Okay.
So yeah, I would, I think in fact, I'll address that. Whoops, is this back on? Okay, I'll address that. That's a good question.
Okay.
Yeah. Any other questions? Anything on guardianship? Because we're kind of moving away from that. Yes?
For the trust, the money that's accounting, that includes the retirement savings and house. So when we're talking about 10,000, or some banks doesn't take until you have 400,000. So
yeah, so depending on the bank, so the bank will manage a lot of banks will include the house as part of the asset, especially if the house is likely to be sold. It just depends on the bank if they'll take your trust. Yeah.
I have a question.
Yes.
On the trustee, if you picked a sibling, would it have to be 18 when you?
They're going to have to be 18 to actually act as trustee, but you could name them, and sometimes in the trust I'll say if over the age of 18 or if over the age of 21 or 25. So you could name them with those caveats, but if they're not 18, they're not going to be able to do it. Yeah. Good question. Okay, are y'all ready? You're all troopers. If you need to just get up and leave, I won't feel bad, or you need to walk around. This is kind of a long morning. Okay, are we ready to go? You're good? Okay. Okay. All right, we're going to get started, but I want to, before we get started, address a couple of issues questions that were just brought up. First of all, trust property that goes into the special needs trust. The question was about the house, and it just depends on the bank or whoever's serving as trustee if they're willing to accept that property. For a lot of reasons, it's often a good idea if you want to leave your child a house to have it be owned by the trust. We're going to talk more about exceptions to SSI and Medicaid and things like that. A child could have a home in their name and still qualify for those programs, but you want to think about what if that child sold the house. So, for example, if I left a home to my daughter and it was in Angela Pakard's name, it's not going to cause her problems with her programs. She's still going to be eligible unless she has to sell that house. Once she sells the house, the proceeds are now going to cause her problems. And because those proceeds are in her name, because the house was in her name, now the only place she can put those proceeds is into a first-party special needs trust. So for that reason, a lot of times if you want to leave a house for your child, unless you really think there's no way that child's going to be selling that, a lot of people will go ahead and leave it to the special needs trust. So then you got to work with the trustee, and the trustee has to accept the property. So most banks are happy to manage a home, but they might hire a company to do all the upkeep and maintenance. So that would just be working with your individual trustee. The one thing I do want to mention that I didn't mention earlier is the ARC of Texas, a master pool trust. They will not take a home. They can't manage real estate. They're not going to manage anything but, cash funds. And let's just talk a little bit more about the ARC Trust. So if you're using the ARC of Texas Master Pool Trust, they are going to have their own trust agreement. So if you came to me and we decided that was the best trustee, we may not even write a trust for you. We may just do a joinder agreement, because when the funds are managed by the ARC of Texas, you're under their rules. Okay, and it makes sense. They can't manage this many trusts individually. They can't be reading everybody's trust agreement. So they've got their set rules, and you join in. You join their trust. Okay? But again, so they will not take property, real estate. So it depends on the trustee, but for most trustees, if you want to name a sibling, if that sibling's willing to manage it, then you could have the home owned by the trust. Most banks, especially the ones that do this often, they're going to be happy to manage a home. They're just going to hire a company to help them do it. Okay, so let's talk a little more about those trustee duties. For example, a trustee is going to need to make sure a tax return is filed every year on the trust. If the trust is growing, you're going to have to pay taxes, or the trustee will pay taxes on the growth, the income. So does the trustee have to be the one to file the taxes? No, they could hire a CPA and pay for it from the funds of the trust, but they need to make sure it gets done. So, that's one thing to think about with your siblings. Okay, what are they going to be able to do? Do they understand the responsibilities if they serve as trustee? And you can leave them instructions. That's what I'm doing with my daughter, very detailed instructions. Although, like I said, she wants to do this kind of law, so she'll probably know more than I do, hopefully, when that happens. But let's see, I was going to say something else. Another thing to think about is your child going to end up hiring a bank investment company? Does your child have the ability to invest funds? Are they going to end up using somebody to invest the funds? Because if so, you want to use that in your calculation for, how much is this going to cost? Is my child already going to spend a lot of money having Broadway Bank invest these funds? Maybe we should just have Broadway Bank be the trustee. All those things are things to think about. And again, if you come into my office, we can go into more detail. There was one other question I wanted to cover. Can you remind me what your question was? Okay, so the question is, are you advising people to get a special needs trust established now, even though you don't need it? And my answer is yes, ideally you would do it now. It's the thinking is, when do you need a will? Before you die. So when do you need a trust? Before both of you die. So honestly, looking around this room, you probably are not going to need the trust for many decades in most of your situations. But, you never know. Accidents happen. So if you can, the ideal thing is get it established now, even if you're young, and just do a revocable trust, and every 10 years kind of just reevaluate, every 5 years, whatever. Who did we name as the trustee? Is this still what we want to have happen? Because remember, if you don't do it now and tragedy hits and you do pass away, that's when you're looking at the first party trust. So yes, ideally you should do it, but then I'm an estate planner. So, you know, that's and I realize this is not a cheap thing to just go out and do. Did that answer your question? Yes. Okay, any other questions on guardianships? I think we covered most everything on the break. We're ready to move on? Okay, let's talk about an ABLE account. So ABLE accounts are really new. The ABLE account, it's called the act passed in Congress is the Achieving a Better Life Experience Act of 2014. If you look at the letters, achieving is an A, better B, that's where they get ABLE, Achieving a Better Life Experience Act. So ABLE accounts were passed in 2014 and different states started rolling them out at different times. Texas got their ABLE accounts rolled out in 2018. Now this is where everyone is getting confused. An ABLE account is not the type of account where you go into Wells Fargo and say, hey, I need an ABLE account. They won't know what you're talking about. ABLE accounts are managed online. The state of Texas has one ABLE account, and if you want to use Texas ABLE account, it is managed online. It happens to be almost identical to many other states. My guess is the same people are managing all these states. For example, my daughter had an ABLE account in Ohio because I needed one before Texas got them up and running. So I opened one in Ohio. Ohio will accept people from other states. That was a good deal for us. We've now moved hers to Texas. I just felt like it was more loyal. I'm not saying Texas is better than Ohio, but you know, Texas does have their own, but in Texas, you have to be a Texan. Isn't that very Texan to say that? We don't take people from other states. Okay, but you do it all online. You do not need a lawyer for this. This is really easy. If your child receives SSI or is under guardianship, it's going to be easy as can be because there's going to be a box you check to just show that your child is disabled. An ABLE account is only for someone with disabilities, and the disability onset has to be before age 26. Now there is a push to maybe make that age be pushed out to 40 or 46, but as of now the law is 26. So these ABLE accounts are for our kids, you know, that have had lifelong disabilities or at least onset. They're not for elderly people or even, you know, someone my age. If I was in a car accident, I couldn't use an ABLE account, okay? So the ABLE account is a non-countable resource. What that means is all these Social Security programs, Medicaid waiver programs, I say Social Security, SSI, they're not going to count. Any amount of money you have in this ABLE account is not going to be an asset for your child. So let me back up. As you know, I think everyone pretty much knows, for most of the programs that are needs-based programs, our kids are limited to having $2,000 in assets. If you have more than $2,000, you're ineligible for these programs. You could have a lot more money. You could have unlimited money in a special needs trust, and in an ABLE account, you can have up to $100,000 in there and still qualify for SSI. You could have up to $370,000 in an ABLE account and still qualify for Medicaid and Medicaid waiver programs. So you can have a lot of money. It's not, you know, in a special needs trust, you could have millions of dollars. But I would submit to you, I don't know why anyone would want to have $370,000 in an ABLE account, because an ABLE account has a Medicaid payback on it. So if you got $370,000, you know, you should be using a trust. You know, my biggest beef with the ABLE accounts is they're being advertised as an alternative to special needs trusts, and they are a great alternative in some situations, but this is not something where you want to just put $15,000 every year and let it grow over the next few decades, because when your child dies, it's going to have a Medicaid payback on it. So you're much better off using a third-party trust with no Medicaid payback. Now, on the Medicaid payback, it is not as strict as a first-party special needs trust. I will say that. For example, a first-party special needs trust, if my daughter were to pass away with money in a first-party trust, Medicaid would say, hey, that's our money. and if I didn't have a burial plan or funeral paid for or whatever, they'd say, ooh, so sorry, that's our money. Give it to us now. An ABLE account, they'll say, go ahead and pay funeral expenses, pay for the, so there is a little more flexibility. The Medicaid payback is also only after the time the trust was, or the ABLE account was established. And like the trust, if I establish the trust tomorrow, it covers anything Medicaid's paid over her whole life. Does that make sense? And the reason I say that is, I'm not opposed to having money in an ABLE account. And even if some tragedy struck, you know, there are ways you would spend that money. But I don't like the idea of it being advertised as a great way to save and avoid a special needs trust because of that Medicaid payback. Does that make sense? So let's go back to this other slide. You can only have one ABLE account per beneficiary. So special needs trust, you could have, you know, as many as you want. There's no limit as long as you're reporting them. But only one ABLE account. So that means, as I mentioned, my daughter had an ABLE account in Ohio. When I transferred to Texas, I had to close the Ohio one down and transfer it to Texas. I don't know, thought it was more loyal to be here. But so you can't, and this comes into play if you've got parents who are divorced. There's only one ABLE account, so you can't both set one up for your child, okay? Now, in that one ABLE account, you can deposit up to $15,000 a year. This number may change in 2019. Well, it will change. It's tied to the IRS gift tax, you know, regulations. So in 2019, you can add $15,000 per year to the ABLE account. So what does this mean? That means if, say, let's use the example, the family's driving down the road and gets in a little car accident. Nobody's super hurt, but there's a small settlement, and your daughter was in the car, so she gets $10,000. Okay, that $10,000 is in her name. Once she gets that personal injury settlement, what happens to her government programs? She has to report, hey, I got $10,000, and if she doesn't do something with that money, she's gonna lose her eligibility. Perfect time for an ABLE account. Why would you go hire a lawyer to draft a first-party special needs trust for $10,000? Move it to the ABLE account. So that's one great way to use an ABLE account. Another great thing about the ABLE account, what if you have, like my daughter has a grandmother who likes to give her, you know, $25 every year. Maybe it's 50 now, I don't know, but she likes to give her something for her birthday or Christmas. Well, my mother doesn't really want to buy something. She lives out of state. She wants to give her money and let her buy something. But if she sends my daughter a check, my daughter has to report it. I got a check from grandma, and you know, and then it's just going to reduce her SSI, and it's just a hassle. But grandma can donate to her an ABLE account, and then Angela can spend the money. Does that make sense? Another great thing about an ABLE account, and I love this, if your child wants a little bit of independence, ABLE accounts typically come with a CareLink card that your child could use to go to the movies, go to a fast food restaurant, and they can use that card so they feel like they've got their own credit card, and then I, as a parent, can control how much money is loaded onto that card, and I can put restrictions on where it can be spent, not spent. And so my daughter feels like she's more independent, she can use it, and she's covered. Now, if I let her use the trust to pay for food or shelter, remember there's that reduction in benefits, we're gonna talk in more detail about that. But an ABLE account is an exception. It's strange, and everyone gets confused on this because it doesn't make a lot of sense, but it's an IRS creation, and an ABLE account pays for qualified disability expenses. What that means is anything that your child with disability needs is probably going to count as a qualified disability expense. And the IRS and Social Security and Medicaid, they have all adopted this. You know, food and shelter is a qualified disability expense. So that means an ABLE account can actually pay for food and shelter, which means my daughter can use that card to go to a restaurant, which is awesome. Does that make sense? Otherwise, she could, you know, she can use a credit card otherwise, and as a trustee of her trust, I can look at it and see if I should pay for it or not pay for it. But the ABLE account provides a lot of benefits that way. Question?
I didn't hear that. Does it reduce the amount of?
So you said that the child can use the ABLE card, like the links to the ABLE cards to pay for housing, food, but will that reduce the amount of the benefits that they receive?
Okay, good question. So the question is, you're saying that the ABLE account can pay for shelter. Is it going to reduce the SSI? And actually, we're going to go into a lot more detail later on, but let me just tell you generally, no. It is an exception. ABLE accounts can pay for shelter. So we're going to get into that, but if you're receiving SSI and it's being reduced by 1/3 because your child is living at home, an ABLE account could pay for the shelter and get them up to the full amount of SSI. You know, okay, if you're a little lost, we're going to get to that if you hang with me, if you can make it another little while. Okay, is that okay? We'll go on. Let me just say something about the cards. I got to be straight with you. Ohio has cards, these cards that you can use. Texas, about 6 months ago, I heard we're getting ready to mail out our cards. This is the month, anytime now. We're still waiting for the cards. Texas, as far as I know, they are not sending out the cards. I do have a client that said he got a card, but then I've never received one from my daughter's ABLE account. So I don't know if the cards are here quite yet, but I can tell you how they're going to work because I know how they work in Ohio, and it's going to work the same way. Does that make sense? So, benefits of ABLE accounts. Okay, let's just go over that, make sure we're clear. So ABLE funds are not counted. So again, you can have all this money and it's not going to count to disqualify your child from government benefits. You don't need an attorney. So during the break, we talked about the high cost of establishing a special needs trust. This you can do yourself, no cost. The account is ready to receive gifts from third parties. We talked about the CareLink card, a less restrictive Medicaid payback, and the ABLE account can pay for food and shelter, unlike a trust, and there's no reduction in SSI. Okay? Any questions about ABLE accounts? Because we're going to kind of move on. All right. Oh, I do want to say something else. Not everything can go to an ABLE account, though. We're going to talk about, we're about to get into SSI. We can sometimes assign income to a special needs trust. Just because you can assign something to a special needs trust, don't think you can assign it to an ABLE account. So military survivor benefits, not going to an ABLE account. Child support cannot go to an ABLE account. Well, you could assign child support to an ABLE account, but it would still count dollar for dollar for your child. So this is not a total replacement for first party trust in all situations. And of course, you've got a limit of $15,000. So if you have that same car accident, your child gets $40,000, you can only put up to 15 in there. All right. Let's just, as we kind of round out this whole estate planning section, let me just remind you, and we've kind of talked about this already, but you really do need to update your wills. And you need to do your estate planning. And let me just mention the will, because sometimes I'll talk to someone, they say, I got a special needs trust, I thought I was covered, and they went and paid a lawyer to do this expensive third-party trust, but they didn't change their will, or they didn't update their life insurance designated beneficiary. Remember, if you don't update your will, and your will says everything to my child, then they're not going to be able to use that third-party special needs trust once the money's in their name. There's a little bit of an exception in Texas. We have a will reformation statute. We could maybe tweak it, maybe get that changed to a third-party trust, but it's going to cost a lot of money. And for life insurance and things like that, it's going to be their money. It's going to have to go to a first-party trust. So you really want to look at your whole estate plan, not just the trust, but update your wills. Think about all those designated beneficiaries anywhere that could end up sending money to your child. Okay? All right. Oh, I do want to cover this before we wrap this up. A lot of my family say, well, what I did is I just left twice the amount to Big Brother because Big Brother is going to take care of little sister when she's gone. This is more common than you would think because people don't want to pay the attorney's fees for a trust. Now, again, I hear all the terrible stories, but I will tell you this is a disastrous plan. It goes wrong in so many ways. First of all, if Big Brother gets divorced, guess what happens to that money? It's part of the divorce estate. It gets distributed out. What if Big Brother dies? That money's gone. It goes to whoever his heirs are, or whatever his will says, or the state of Texas says. What if Big Brother has his own creditor problems, bankruptcy, it's gone? What if Big Brother has his own car accident and somehow they tap into this extra fund he has because he doesn't have enough car insurance? Or what if Big Brother just doesn't want to pay for little sister? Or what if Big Brother's wife doesn't want to pay for little sister? There are so many ways this goes wrong. So I just have to make a plea for you to not depend on this strategy. It's very dangerous. Now, I'm not saying it never works. Again, there's probably it works in some situations and those people don't come to my office. But I can tell you it can go wrong a lot of ways. So it is worth it to do the trust, to have that security. All right, I'm going to keep going. Let's see. Oh, I think we've covered all that. Okay, I think we're ready to talk about SSI, all that Social Security. Are y'all ready? Everyone's okay? Stand up, jump around if you need to. I know it's a long morning. Okay. Social Security, this is a biggie for all of us. I think it's best if we kind of understand the whole Social Security system. So let's kind of go a general overview. Most of us, when we're paying our FICA taxes, we know we're paying into Social Security retirement. That retirement means that one day we're going to get this benefit paid to us, and when we turn 65, we're going to get Medicare health insurance coverage. And then we're going to just figure out when we take our retirement benefits, and it might be at 62, it might be at 67, it might be at age 70. And when we choose to take those retirement benefits will affect the amount we get. So my full retirement age is 67, and I can look online and see how much I will get if I retire at 67. If I want to hold off on taking my retirement to age 70, I can see how much I'm going to get. So I choose when I take it. 70 is where it maxes out. So always take your retirement by 70. There's no reason to hold off after that. Okay. So this is what I just said. If you're born after 1960, your full retirement is now 67. We just covered that. All right. Who else gets to benefit from my retirement benefits? Well, a spouse can collect off of my retirement if the spouse is age 62 or older, or if the spouse is caring for a child under age 16 or a child who's disabled. And also, a child can get benefits from the retirement account, from the worker's account, if the child is not married under age 18 or 19 if they're in high school. And this is what I want you to really pay attention to. Or if the child is not married and disabled before age 22. Okay, so I want to make sure that sinks in with everyone. So this means my daughter, Angela, if she does not marry because she was disabled before age 22, she will take, when I retire, she will take 50% of my retirement, and it won't lower my amount. Whatever I get, she'll get 50%. When her dad retires, she's going to take 50% of his retirement because it's going to be a lot more than mine. Yeah. Retirement, by the way, is calculated. I think it's 35 years of earnings. Like I said, I took 10 years off and didn't work. So, her dad's earnings are going to be much higher than mine. So this is really important to understand. Your child can potentially take off of your work record. Ex-spouses also have rights. We're not going to get into that. If you're in that situation, talk to me later. But ex-spouses sometimes can also take from the retirement funds. So what happens if the Social Security worker dies before they start getting their benefit? There are survivor benefits. So if my husband passes away, I get benefits from his work record because I'm a spouse of more than 10 years. His child also gets benefits if he passes away. Any minor child will take benefits, or any adult disabled child. Again, disabled before age 22, continuously disabled. So that means if my husband passes away, my daughter will get up to 75% of his benefit. I say up to, it's a little more complicated, meaning if there's other members of the family drawing off of that benefit. But it will be up to 75%. So say, I hope my husband passes away when, he's very old, but say, if we're both old and I have my own retirement, he has his own retirement coming in, and he passes away, she'll take 75% of what he was getting. So this is huge, but only if your child was determined disabled before age 22, okay? What happens if the worker who's waiting to retire becomes disabled? Then there's disability insurance. When we're paying our FICA taxes, we are paying for insurance in case we get disabled. So I'm paying every year those taxes. If I become disabled before I hit my retirement age, I can start drawing early retirement basically under disability as long as I can show Social Security that I am disabled. This is the program where our kids are going to jump in. Okay, so when we say our children are applying for disability, this is kind of the world they're living in. They're trying to tap into that disability insurance first, and if they can't tap into this program, they're going to go to a welfare equivalent, which is SSI. Okay, so when we say our kids are applying for disability, it's the same program as if I became disabled or you became disabled, where you tell Social Security, look, I can't work anymore, I need my retirement early. Okay, so Social Security disability insurance is Title II disability. It's also known as SSDI, also known as DIB. It's all the same, okay? It's confusing because there's so many initials, but DIB, SSDI, what it means is some worker paid into the system, paid enough FICA taxes that there was disability insurance. If you qualify to receive that benefit, you'll get a monthly payment and you'll get Medicare coverage after about 2.5 years. Okay, so they don't give you the Medicare automatically. Remember, you get your Medicare when you're 65, but if you become disabled, you have to wait to get the Medicare. So if our children qualify for disability under this program, they'll get Medicare after a couple years. Okay? So what is the amount of money you get if you're getting disability? It totally depends what FICA taxes were paid in. It has nothing to do with need. So my daughter may have major medical bills. That's not going to affect what she gets for disability insurance through Title II. It's all based on what you paid in, okay? You're either disabled or you're not disabled. And if you're disabled, we're going to look at the earnings, and that's how you determine what you get. So SSI, just to make sure everybody's clear, SSI is where a lot of our kids start. That's where they get a monthly payment and they get Medicaid, automatic Medicaid. SSI, it kicks in if our child can't qualify under Title II disability. So the first step is when you apply for disability, and I'll use my daughter Angela for example, when she is on SSI. So when she went to apply for disability, the first thing they do is they check her work record. Did Angela work enough? Did she pay enough FICA taxes that she has disability insurance? The answer was no. So the next thing they're going to check is, does she have a parent who is retired, disabled, or deceased? If she had a parent who was retired, disabled, or deceased, she would take under that parent's work record as long as she disabled before age 22, okay? In her case, both her parents were working, and so she didn't qualify under Title II. Now, one day she is going to qualify under Title II, but for now she didn't. So because she couldn't qualify, she gets kicked over to the welfare system. That's SSI. So for a lot of us, that's where our kids start because both parents are working or they're not at the age to take retirement. So once you're in the SSI system, this is a needs-based system. We call it means-tested, needs-based. It's basically the welfare system, okay? Because it is the welfare type system, I know that's not a very nice way to say it, but that's what it is. It's only available for people who are poor and really need it. So if my daughter has a big old trust account, she's not going to get SSI because she's not poor. She doesn't, she's not showing that she's needy. So she's going to be ineligible because she's wealthy. And we're going to get into more details, but the way you get around that is you wait until your child is age 18. Because remember, until your child is 18, you have a legal duty to support your child. So your money is their money. So my daughter, if she would have applied before she was 18, she wasn't going to get on SSI because I have a legal duty to pay for her. Once she was 18, my money's not her money, and she is poor. She doesn't have any money in her name. Now, anything in a special needs trust, that doesn't count. That's why, if it's in a regular trust, it counts. If it's a 529 plan, it counts. It's her money. If it is, depending on how your 529 plan is written, if it is just, CD, stock in her name, some bank account in her name, life insurance that could be cashed out, she could go in and say, I need this, and she can cash it out, Those are assets for her. All of her assets altogether have to be less than $2,000 because most of our kids are in that situation after age 18. They qualify financially, okay? So in 2019, the maximum benefit for SSI is $771 a month. So that's the most everybody gets. Again, this has nothing to do with my daughter's medical bills. It is a set amount, and we're going to talk about how it gets reduced by 1/3. Going back, if she were to qualify under her parents' work record, who knows what her amount would be. You know, I looked it up the other day. If I die, she gets, I think, $695 because it's just not that much money in my account. If her dad passes away, it's over $2,000. So there's a big difference depending on how much you've worked, how much you've earned and put into the system, okay? All right, same thing on Title II benefits. I just want to emphasize this. Disability insurance, if you become disabled, your children have benefits off of your work record. I think we've already covered this. Basically, the important point to know is if your child is disabled before age 22 and they have a parent who is either retired or disabled or deceased, that's when they tap into their record, okay? I'm sorry? Yeah, the question is, so if they're under their parents' work record, do they get more than the 771? It depends. So if the parents had quite a bit, you know, that their benefit was pretty high, they would get more than 771. But it's up to 50% or up to 75%. So for a lot of our kids, yes, it will be more. Okay. That program where you draw off of your parents' work record and or grandparents' work record, if it's or a legal adoption, kind of depends on your legal arrangement. It's called Childhood Disability Benefits. Okay, it's also known as CDB or DAC. So if you hear about DAC benefits, CDB is the official name, but it was before it used to be called Disabled Adult Child Benefits, and so most people still call it DAC benefits. That is a disabled adult child under a disability which began before age 22, unmarried, and this is what I want you to pay attention to, continuously disabled since age 22. This is a little confusing because you're thinking, well, if my child was disabled at this young age, she didn't all of a sudden lose her disabilities. The key here is Social Security's definition of disability. It's not did your child get a diagnosis before age 22. Are they considered disabled in Social Security's eyes? And Social Security looks at ability to work, okay? So I want to make sure everyone's clear on this. So when we say continuously disabled since age 22, that means did your child start working full-time? Did they go off of their programs because they had a full-time job, they were earning all this money? If they did, they were not continuously disabled. Because disability, again, is Social Security definition. Does that make sense? And we're going to talk more about that. So how do you prove to Social Security that the disability began before age 22? By far, the safest, most secure way to do it is go get on SSI or SSDI before that age. You can argue, hey, look, I know Angela is 25 now, but I swear she was disabled before 22. Let me show you all her school records. Let me show you all this. And I might win that case, but it's tough. And you do not want to be having that fight if you can avoid it, especially if the child, it happens all the time. You know, a child is now 50, trying to go back and use school records. The reason is, it's not the diagnosis, it's the definition of disability for Social Security, which has to do with substantial gainful activity. Can your child engage in substantial gainful activity? That means, can they work? Can they work a substantial amount? Can they make a decent amount of money gainful? And activity means they're doing it. They're just not getting money coming in without their work. Now, we're going to get into more detail on that. I don't want you to all think I'm saying our kids shouldn't work. Our kids can work, and they should work. And there's a lot of ways, there are a lot of programs out there to let our kids work. And I think it's a terrible thing for people to say, oh, my child's not going to work because I don't want them to lose their benefits. I do not want my daughter stuck at home. But if they're going to work, you know, how much are they working? How much are they earning? What kind of program are they under? So I think my daughter works, but she doesn't work a gainful amount. She doesn't make a ton of money. She doesn't work a substantial amount. and earn a gainful amount is what I meant to say. So we can get into more detail, but I just want to make sure everyone's clear, because just because your child has the diagnosis doesn't make this automatic, okay? All right, so continuous disability means they maintain that eligibility for SSI and SSDI. If you get qualified before age 22 and they stay on the program, you'll be just fine. And I just bring this up because I'll be honest with you, I didn't go apply for benefits for my daughter when she was 18. As I mentioned, we were living in Boston. We were doing great. I thought she has good health insurance. We're doing great. I didn't understand this area of law like I do now. And I just didn't do it. And now that I understand this, I really push parents, if you think your child is going to qualify to receive benefits off of your work record, do this before they're 22. You know, get into the system, because it's going to make it more secure. Okay. If you do want to apply for SSI, SSDI, you can apply online. You can go into the local office. You can use an attorney. If you call, you can get into their system and get a protected filing date. Again, you're going to want to wait until your child is 18. Because if you go before that, they're going to look at your income and your assets, and for most people in this room, your child's not going to qualify. Do you need a lawyer to do it? First of all, you should know all lawyers charge the same thing. This is not something where you have to ask around. It's set, okay? All lawyers get paid 25% of the back pay. So that means if you call and you say, I want to come in and apply for SSI, the day you make that appointment, you're going to have a protected filing date. That's the day they're going to start counting your application as being in. If it takes 6 months to get approved, you're going to get 6 months of back pay. If you're one of those people that has to fight for a couple of years, you're going to have 2 years worth of back pay. Whatever that back pay amount is, the lawyers get 25% of that. So if it's a quick and easy approval, the lawyer's fees are much lower. There is a cap. I think the cap is $6,000. My law firm does this all the time. I don't personally do it. I've done it for a couple clients who I just had to help them because, anyway, for other reasons. But that's standard, okay? So do you need a lawyer? Do you need to pay that 25%? I think it just depends on your individual circumstances. And we'll get into more detail. If you think you can qualify without using an attorney, go for it. If you want to try to qualify, and then if you get denied, if you do get denied and you think you have a good case, I'd go talk to a lawyer. I would say don't fight a denial on your own. At that point, you don't have to pay anything up front. If you don't win, you don't owe anything. So if you're denied, I would definitely go to an attorney. Otherwise, it kind of depends, and we'll talk more about how you qualify medically. My daughter has so many disabilities, it was very easy to get through. If your child has Down syndrome and some real clear disabilities, you probably don't need an attorney. If your child has high-functioning autism, is diagnosed with high-functioning autism, and they're working, that might be a tougher case, because again, we're looking at, can your child engage in substantial gainful activity? Can they work, okay? So how do we determine if someone is disabled under these programs? They have to be medically determined, and then they have to be technically eligible. So medically determined to be disabled and technically eligible. So the medical qualification is going to be different for a child versus an adult. So that means, this is my daughter when she was little, you all probably recognize this definition in the school system and other programs. Our children are considered disabled if they're under age 18 and they meet this definition. They have a medically determinable physical or mental impairment or combination, and the impairments result in marked and severe functional limitations. Basically, if your child's got a diagnosis and they've got delays in school, if they're in the special ed program, they're probably going to be considered disabled as a young child, okay? So if you go apply, if you happen to have very low income and your child would qualify for SSI, before they're 18, then this is going to be an easier definition to meet, an easier criteria. And I think most of us are looking at age 18 or over, so I won't go into a lot of detail. If you have a young child, you can talk to me. There are 6 domains that they look at, and I can go over this with you. They're going to look at school records. They're going to look at medical records. We're not going to spend a lot of time on this. If your child is born with these symptoms, there's an automatic qualification while your application is pending. Our daughter was actually born 13 weeks early and had very low birth weight. So we were young, poor college students. We qualified immediately, you know, before we started earning money. So some of these things happen quickly. I'm not going to go into a lot of detail on this. Basically, doctors, teachers, therapists, you know, they all go into this system. All right, talk to me later if you have a minor child. Let's move to adults, okay? Once we're looking at an 18-year-old or older, this is where we switch to that substantial gainful activity definition. So, is your child unable to engage in any substantial gainful activity due to a severe impairment that has lasted or is expected to last at least 12 months or more or lead to death? Okay, so it comes down to substantial. Can they work quite a bit amount? When I say by Social Security's definition, I think they say 30 hours or more. I would tell you maybe 20 hours or more. Because if you're over 20 hours, it's a closer call. So if your child is working a part-time job, that's awesome. Get them out of the house, let them do something. But when you're going over 20 hours, you need to just kind of evaluate, is this gonna affect their program? You know, is this gonna cause them issues with their eligibility? But by the way, let me just say, if your child is capable of working 40 hours a week and earning a decent money, I would celebrate. You know, sometimes I just don't understand when parents are fighting to live in this system. If my daughter could work 40 hours a week and make a good income, I would be thrilled. So count your blessings. But if you're not in that situation, you know, just know that if they can only work some, you want to watch the amount that they're working and see how it affects their benefits. Gainful, how much can they earn? That varies every year. Social Security gives a certain number. This year it's $1,210 a month. I would say if your child's earning more than $1,000 a month, it's probably close to gainful, okay? So again, you want your child to get out and do things, just to understand the impact. And as long as they're not working a substantial gainful amount, they're gonna stay on these programs. And there's all kinds of reporting issues, we'll get into that. But okay, so medical determination. You should know that there is a blue book of listing impairments. So what that means is if you Google SSA Blue Book, you can type in your child's diagnosis and see what Social Security is looking for. If your child meets the definition that is written up in that blue book, they're going to qualify automatically. Okay? So if you don't meet the explanation under the blue book, it doesn't mean your child's not going to qualify, it just isn't going to be automatic. So these happen to be my daughter's diagnoses. She has epilepsy. In the blue book, it's called seizure disorder, but her seizures are totally under control, thank goodness. So she would not qualify based off of epilepsy because she's doing great. She has these other things. Her myasthenia gravis is very severe and she qualifies under myasthenia gravis. So for me, it was a super easy process. She was qualified in 2 months. So I would say if your child, for example, has Down syndrome, this is the blue book listing for Down syndrome. If it's non-mosaic Down syndrome, this is what you need. And if you can get that, it's going to be an easy qualification. So if you look at the blue book and this is you, then you probably don't need a lawyer. Unless you just don't want to mess with it. Does that make sense? But if you don't qualify based on the blue book listing, then we're going to go to this other criteria. This is for everyone who doesn't qualify automatically, okay? And this doesn't matter if you are 58 years old or 18 years old. We're all going to be evaluated under this system, okay? For all adults who don't meet the listing, are you working? Is your medical condition severe? Does your medical condition meet or medically, well, that doesn't make sense what I said, but if you get a listing, you're not in here. Can you do the work you did before? Can you do any other type of work? Okay, so what this means is if I become disabled, the first thing I'm going to be evaluated is, can I keep being a lawyer? That's what I was doing. If I can't keep being a lawyer, then I'm going to be evaluated under, is there some other type of work I can do? If I can do something else, then I don't have to be able to keep being a lawyer. If there's something else, I'm not going to qualify for disability, okay? So that's the standard steps that everyone goes through, including our kids. So what this means, can our kids do the work they were doing before? If they've never worked, then that's not going to really apply. But look at this last question. Can you do any other type of work? So your child who's applying for disability, can they work? That's how they're going to be evaluated. And as again, if they can work, hallelujah, count your blessings. But just know this is what it's about. And the reason I say this is when you go in for an interview with Social Security and they say, can your daughter work? You don't want to say, oh yeah, do you see what I mean? You'd want to say, I hope she can work, but she's going to need a job coach. It's probably only going to be part-time. She's going to be very limited in how much she can work. She's going to need a lot of support. I don't know if she can hold a job, but we're going to try to at least get her something. You see the difference? Because you don't want to give them an excuse to say denied. Because if you say, yep, if you go in there and your child is working 40 hours a week, and you say, oh yeah, this is going great, we love it, but my child's diagnosed with autism, but man, they got a great 40-hour-a-week job, you're going to get denied. Okay? All right. Your best evidence of disability is going to be medical records. So all those IEP records are awesome and you need them, but Social Security, they like medical records. So if you have a child with high functioning autism, you may not be seeing the doctor very often. I would get to a doctor a little bit. Because there's kind of this general philosophy, if this disability isn't severe enough to ever see a doctor, how severe is it really? So go to the doctor and be frank about how your child is doing. And I say this as a mom. I remember I used to take my daughter to the doctor and I was just so exhausted by the time I got there. I was just like, yeah, she's doing great. Can we go? I did not want to go into any detail about her struggles because it was just, like I said, hard to even get there. But you don't want to lie, you don't want to exaggerate, obviously, but if you've got some struggles, tell the doctor, let them get it in the medical records. Be real honest and upfront about what's going on, because those medical records are going to be evaluated, okay? How long does it take to get approved? It is, again, depends really on your individual case. If you've got one of these cases where you meet a listing, it's going to be quick. So this standard timeline doesn't apply to most of our kids, but if you've got something where you're going to have to go through a bit of a fight, it could be a very long process. Just know that. And the most common one is high functioning autism. That could be up to a couple years before you really get that down. Now, if you get denied, don't give up though, because honestly, people get denied left and right. It's very common to be denied. It doesn't mean you're not going to get approved down the road. It means you're probably going to have to appeal. But go see a lawyer at that point and they can walk you through it. Okay. And when I say lawyer, I actually don't do those, but if you call me, I can get you in touch with the lawyers in our firm or any other firm. But, get some help before you just give up on a denial. Okay. So you have to be medically determined to be eligible. Whether you are going to be in SSI's world or SSDI world, that medical determination is the same. Okay, it's the same. But technical eligibility is going to be different. We've already kind of talked about this. But to qualify for Social Security disability under Title II, this is under a worker's record, then you have to have enough credits. So that means if I'd only worked, a couple years, I'm not going to qualify for disability under my work record. You have to have a certain amount of credits, and it depends how old you are. So, for example, if your child worked for a while, but then applied for disability, and say they're only 23, but maybe they worked a couple years, they might get it off their own work record because they only need a year and a half. You see what I'm saying? But someone like me, I'm going to have 7.5, 8 years worth of earnings before I can qualify. Did you follow that? So, okay, so let's go back to let's use our kids. So if our kids are trying to get into this program, then they're looking at their parents, and their parents have to have the credits in there. So if we have a mom who stayed home for 10 years like I did and just worked a little bit, I may not have enough credits for my daughter to qualify. How do you figure this out? Go create your own online account. Go to ssa.gov and create an account for, if you're married, do one for dad and one for mom, and you can see exactly how many credits you have, how much money you'll get if you retire at this age or this age or this age, what your kids will get, okay? Oh, it's right there. How about that? ssa.gov, it's going to give you a list of lifetime earnings, your benefits, and what your family members will get if you receive Social Security or you die, okay? All right, this is just kind of what it's going to look like. You see, it's going to say age 70, my payment would be this amount, age 62. And think about that. It's going to make a difference, because as you figure out what age you want to draw your retirement, you want to think not only about the amount of money that's going to come to you, but it could potentially go to your child the rest of their life. So I told my husband he's obviously working till 70, you know, because he will, well, you know, he's not going to draw his retirement till 70 because then he'll get that amount, but then it'll pass to my daughter for all those years after we're gone. You know, does that make sense? Okay, we've kind of talked about this already. I'm going to try to go a little faster because I know it's been a long morning. If you're disabled and you don't have your own work credits, that's when we go into SSI. We already talked about that. We're going to skip non-financial. Technical eligibility for SSI. This is the welfare program. This is the needs-based system, and this is where you can only have limited income, limited assets. We've talked about this. You're ineligible if you have more than $2,000. Okay? I'll go a little bit faster because I think we've covered a lot of this. Assets in Social Security world are called resources. So a resource is anything owned by the claimant that can be converted to cash unless excluded by law. So that means if you can cash it out and get money for it, it's going to be a resource to you, okay? Resource to our kids. It's going to be measured on the first day of every month. So when I say they can only have $2,000 in resources, every single month if they're on SSI, they have to be under that $2,000. So if they're getting SSI payments and you're not spending them and their bank account goes over $2,000, you're ineligible now, okay? We already covered that. There are exceptions. These are the exceptions. Other than the first $2,000, you can have a home of any value, you can have a car of any value, household goods, and as we've already mentioned, you can have a special needs trust or an ABLE account. Those are exceptions to the assets. So this is where the special needs trust comes in. Our kids can stay eligible for their programs if the money's all in a special needs trust or an ABLE account. And again, notice there, the home, they can have a home in their name, but you got to remember what happens if the home gets sold, okay? SSI technical denial. Oftentimes an individual won't qualify for SSI, not because of medical reasons, but because they have an educational fund or they have a bunch of money from a PI settlement. You can typically move that money to a special needs trust. Of course, it has to be a first party trust. In some cases, you can move it to an ABLE account. I'm going to keep going. Income limits. Okay, there are income limits to qualify for SSI. This is any income that comes in any day of the month has to be reported. All right, and income can disqualify you for these programs. If you have income from SBP, military survivor benefits, child support, adoption stipends, all of those can disqualify somebody. Okay, so that you can usually send that to a special needs trust, typically not an ABLE account. There's just by law certain things that can't go to an ABLE account. By the way, I said compare Miller Trust. A lot of times you'll hear about a qualified income trust or a Miller Trust. That is used when someone's trying to qualify for Medicaid for a nursing home. What we do there is we take the income from Social Security or a pension and we put it through a Miller Trust so they can qualify for the nursing home Medicaid. That only works in that particular case. All right, we're gonna keep going. I think basically if you have child support issues, why don't you come talk to me after or call me, after you rest. Because we should cover that. But you should know that in Texas, lifetime child support is available. If the child requires substantial care and personal supervision and will not be capable of self-support, then and if that disability was known to exist before the child's 18th birthday, then child support is available lifetime, but it's not going to happen automatically. So if you're in that situation, you're going to make sure you need to make sure your family law attorney knows about this. And you've got to make sure that any child support is sent to a special needs trust. If you have that situation, I'm happy to give your family law attorney the language they want to put in to the divorce decree. Does that make sense? Okay, we're going to move on. We're going to skip all the disabled military child protection issues. If you're in the military, talk to me about that because you're going to want a first party trust, and this is all these slides refer to how that is determined. Is anyone here in the military? Okay, we can talk about it later if you want to. Okay. All right, quickly we're going to talk about the 4 types of SSI income. For SSI, they say there's unearned income and earned income, in-kind support and maintenance, and deemed income. I'm going to go real fast, but we can talk after if you want. All right, SSI earned income. This means, I got to slow down. I can't go real fast. Sorry. I got the message. Don't go real fast. Okay. SSI earned income means our children are working and earning money, okay? Obviously, that is a great thing, but we have to report it. When we report it, the SSI amount will be reduced. Now, our children, Social Security wants to encourage our kids to work, obviously, and even if they're going to still stay on their program, they still want them to have other sources of income. So they will let our children keep the first $65 of earned income, plus they get to keep the first $20 of any kind of income, which means if my daughter works, her first $85 she's keeping. After that $85, she has her benefits reduced by 50% of whatever she brings home. Does that make sense? So you get the first $85 free if there's no other income coming in, and then there's a reduction of 50%. So for every $2 she earns, her SSI gets reduced by $1. Let's do an example. If she earns $485 during a month, she keeps the first $85. We divide the remaining $400 in half, which gives us $200. So her SSI check is going to be reduced from $771 to $571 because I reported $485. Everyone clear on that? So you notice though, Angela's going to have a lot more money if she's working because now she has her SSI reduced to $571, but she's got an extra $485. So it's to her financial benefit to work, and of course it's to her emotional and mental benefit to work if she can. So I'm actually a big believer in letting our kids get out and earn some money. Okay, and there are a lot of programs where our children can work and not have their benefits reduced. For example, if our children are still in school, but they're under age 22, they get to keep all of the money. There are some limits, but our kids usually don't reach it. It can be up to $1,870 a month with a $7,500 calendar year total. Okay, I'm not going to get into these details, but there are programs, impairment-related work expenses, plan to achieve self-support. There are certain programs that will let our children work and keep more money. If your child's working, talk to me and we'll see if you might qualify for one of these programs. All right. Unearned income. This would be income that they're not working for. And if they have any unearned income, their benefits are reduced dollar for dollar. They don't get the first $85 free. Okay? There's a first $20 disregard. So if there's no other, no matter where the money's coming from, the first $20 they don't have to have their benefits reduced by that. After that, it's dollar for dollar. So that means if there's child support, other than the first $20, it's dollar for dollar reduction. So if you have $1,000 in child support, your child's ineligible for SSI because we're going to reduce it by 980. 771 is the maximum this month. Subtract 980, they're ineligible. They got nothing. You keep your Medicaid if you still have at least $1 in SSI. Then you're going to keep your Medicaid. There are ways to keep your Medicaid even if you're at zero, but that's sort of beyond the scope of what we're covering. But does that make sense? So that means if grandma gives my daughter a gift of $5,000, she reports the $5,000 to SSI. She obviously got too much income in the month, right? So she's ineligible for that month. So they say, oh, we shouldn't have paid you in that month because grandma gave you $5,000. Now what happens? She has to report that income. If I don't take care of that income and move it somewhere, it becomes an asset for my daughter. It becomes a resource. So the start of the next month, they're going to say, what happened to that $5,000? If it isn't moved to a trust or an ABLE account or spent down, now she's ineligible for the next month, and so on. You follow that? Okay. We already talked about this. Deemed income is when a parent's income counts for the child. And we've gone over that. Up to age 18, our income is deemed to our children. So most of them will not be eligible. There is a chart in your folder that has a deeming eligibility, which shows you if you are on a low income household, it will show you how to figure out how much money you can have coming in, excuse me, and still qualify for SSI. Okay, in-kind support and maintenance. This is our last big topic, we're almost done. This is where our children have their SSI reduced because someone else is providing food and shelter for our children. And you think about this from the perspective of, you know, it's a welfare needs-based program. Remember, it's only for people who need it. So if mom and dad are giving daughter free room and board, the argument is she doesn't need as much. See, so it kind of makes sense. So what that means for most of us, our child starts out, they get qualified for SSI. If they're living at home, Social Security will say, okay, they're living at home with you, they don't need as much, we're gonna reduce it by 1/3. So this year, instead of getting $771 a month, they would get $514 a month. That's because they have in-kind support and maintenance. It's a type of income. We call it ISM, all right? So, we already went over this general rule. If you live in somebody else's house for free, your benefits are reduced by 1/3. Now, by the way, that means it's not just if you live at home, if the special needs trust is paying, see, then their benefits are reduced. Okay, so either mom and dad, a trust, grandma, if someone else is paying for their room and board, it's gonna be reduced. Okay, fair share exception. This is how we get around it. If our children will pay their fair share of the expenses, then we can get them up to the full amount. So what are the expenses Social Security looks at? And by the way, there's a handout in your folder with this. There are 10 set expenses we look at. So this is what counts: food, a mortgage, real property taxes, rent, heating, fuel, gas, electricity, water, sewer, garbage. So you notice cell phone is not on there. Cable, not on there. So we don't care who's paying for the cable or the cell phone. But if mom and dad are paying the electric bill and the water bill, then that matters. So how do I show that my daughter's paying her fair share? I get a copy of all these bills, and food, by the way, you don't need to take your groceries receipts, but the food, you just say, this is what our household spends on food. But everything else, you're gonna want a copy of your mortgage statement, your energy bills, you know, whatever you have. You give them to Social Security and you say, here's our bills. My daughter is gonna pay her fair share. How do you figure fair share? You figure out how many people are living in the house and divide the bills by that number. So it's pretty simple. So if you have 4 people living in the house and your household bills are $2,000, then the fair share of that one person is 2,000 divided by 4, 500 bucks. Did you follow that? Okay, so what happens if the SSI recipient doesn't get enough money that they can't afford to pay their fair share? And that is most of our cases at some point. It's just my husband and I and my daughter in the house. There's just 3 of us. My other kids are all out of the house. Our mortgage payment is, I don't know what it is, 21 or something, 2,100. So see, she's already not gonna be able to afford her 1/3 share, because we can only divide all those costs by 1/3. So Angela cannot qualify to pay her fair share just based on showing the bills. So now I have to do something extra, okay? So now I can either go get a lease agreement. I can have her sign an agreement with me to where she says, okay, every month, mom and dad, I'm gonna pay you this much amount for the room and board you're giving me. And then I turn it into Social Security and every month she pays me. This works. I'm not a huge fan of it, because then that's income to me, first of all, and I don't want to report it and pay taxes on it. And so I don't like that. And also for a lot of our kids, they might not have capacity to even sign a contract. If you're under a guardianship, what are you going to do? Sign a contract as a guardian with yourself? It's just messy. So this is not my favorite way to do it, but it is an option. Another option is this ABLE account that we talked about. As we mentioned, ABLE account can pay for qualified disability expenses, and there are clear regulations that say this includes housing. I do this all the time with my clients. I do it with my own daughter. You can have an ABLE account, pay the shelter expenses, and report it to Social Security, and you get the full amount. Okay? So this seems kind of crazy, but let me just explain. So what I do with my daughter, you know, she has a special needs trust. I've moved money from her special needs trust to her ABLE account, Her ABLE account actually pays me every single month what she's short. Like, we figured out her fair share, and whatever she's short, the ABLE account pays me every month. And because I've reported that and I do it every month, she gets the full $771. So it seems a little bit crazy because it's my money that just went in a big circle. You know, it was my money that went in the ABLE account, and then she ended up paying me back the money. But once the money gets to the ABLE account, it is considered her money by law. And if it's her ABLE account, it's considered her money. So if she uses it to pay for housing, I'm just telling you, it works. So if you are in that situation, oh, here I have an example. If she needs, her fair share is $971 a month, then she's short $200. So every month we can take the $771, she can pay me what she's getting, and her other $200 could come from her ABLE account. If you need help with this, I have a letter that's just a sample letter. I don't charge. This is just kind of pro bono thing. Call me and I'll help you if you like want a sample letter of how to explain this, okay? But this is important to understand. You can't just do this and not report it to Social Security. You have to work with them. And if you establish an ABLE account, if you establish a special needs trust, you have to tell the Social Security Administration. You have to tell the Medicaid office. Anytime there's a financial change, you have to report it. By law, you have to report these changes by the 10th day of the month following the change. So if you create a special needs trust tomorrow, you got to report it by August 10th, okay? So make sure you do that. If you don't report things, Social Security can go back and hit you with a big overpayment. So for example, if I create, well, I don't want to, if Angela gets a bunch of money from an inheritance from grandma and I forget to report it, and I go along for a year and Social Security doesn't know, and then one day they realize, oh my goodness, she was ineligible that whole year. Guess what they do? They send me a big bill. So they don't just say, shoot, okay, well, let's get you on track. They say, oh, you owe us for every one of those months. So if you work something out with Social Security and say, we're going to use an ABLE account to pay for ISM, to pay fair share, and you don't do it, Social Security can go look at your ABLE account. If they say, ooh, you didn't transfer it in July, August, and September, you owe us those 3 months, okay? So I know it's been a long morning. This is my contact information. If you feel like your mind is like gonna explode and you just need to stop for the day, but you have questions when you go through this, feel free to call me. You can email me. I don't charge a consultation fee for parents who have children with special needs. So if you want to just come in and sit and talk, we can do that too. Otherwise, I'm going to stay for another half hour and just take individual questions if you have them, and then we'll get out of here by noon. All right. Thank you all very much.